Audio check for stream. Audio check. 1, 2.
If you all are ready, let's go on the record. Good morning. Today is February 7th, 2023. The time is 9:03. This is a continuation of the evidentiary hearing in the case captioned as in the matter of the application of Union Electric Company doing business as Ameren, Missouri for approval of a subscription-based renewable energy program. It's the Public Service Commission file EA-2022-0245. My name is Ken Sire, and I am the regulatory law judge presiding over the hearing, which is taking place in the Commission's hearing room in the Governor Office Building. All right. First thing I'd like to cover this morning before we take any witness testimony, Mr. Lowry. It came up during Ms. Forsberg's testimony yesterday. She had mentioned that there were work papers and such that would support, I believe, her schedule S1 and S2.
I recall, Your Honor, yes.
Okay. Would it be possible to submit those documents as one of your exhibits? And if there are any other work papers that would support her her modeling of the investment tax credit versus the production tax credit, if those could be included with that exhibit as well, or a separate exhibit.
That's absolutely no problem, Judge. I will say that in terms of, so I'm going to ask logistically how you'd like us to do this. These are, I believe, you know, there's big spreadsheet models. There's a lot of tabs and data behind them. Printing them is probably, might not even be possible. So if we submitted them electronically as an Excel file in the docket and offer, I mean, how logistically would you like for me to do
Well,
that?
it doesn't necessarily have to be filed through the electronic filing system, because I assume all the other parties have these documents.
How about if we just submitted a CD and we offered the CD as an exhibit?
Well, or I would suggest that you just email.
Okay.
Attach it to an email to, I believe, exhibits@psc.mo.gov.
Okay.
Exhibits plural with an S on the end.
Okay.
And I believe that'll get it to us.
Would it be acceptable if we could do it at the end of the hearings today or tomorrow, or with it?
By the end of tomorrow would be perfect.
That's no problem. Yeah.
Okay.
Yep. Thank you.
Right.
Will that be exhibit 15?
Yeah, we want to sign a number now.
That's fine. Yes, if you could make that exhibit 15, because 14 was your opening, 13 was your opening.
Your Honor, if I may, I'm going to get in the habit of speaking into the microphone from the beginning if I can. If I may, the question has come up, are you speaking of work papers for the direct as well as the SIR rebuttal, both, or what?
I took it as SIR rebuttal, Your Honor, because that's when that comparison has the latest information, but I mean.
That's what I took it as too here, but my staff has asked that question, and so they want to know.
Well, work papers that would support what testimony or schedule in the direct testimony.
So if we, and which is, we're happy to do this as well, but Ms. Forsberg submitted direct testimony, and there would be work papers supporting some of this information there. Then she submitted supplemental direct at a time when it appeared that we were going to pivot only to the PTC, and then submitted SIR rebuttal when the question has arisen about whether the ITC, and I think as the testimony indicated, the company believes it is going to be the most favorable. So we can submit all those or just a part of them, whatever the bench prefers.
I would prefer all of them.
Okay.
Well, Your Honor, if I may, that feeds into a problem that arose yesterday and in this hearing. Now we're talking about bringing work papers in support of direct testimony, which he modified or withdrew. and therefore staff did not respond to. And so we're going to have workers supporting ideas or themes that staff has never had a chance to reply to. So I just want to advise the commission of that.
Okay.
Judge, those work papers will be highly confidential, just for the bench's information.
Understood. All right, then let's proceed. And correct me if I'm wrong, Mr. Lowry, but you have no further witnesses to call, correct?
That is correct, Your Honor.
All right. Then, Ms. Plescia, would you call your first witness?
We would like to call Morris Brubaker, please.
All right. Good morning, Mr. Brubaker.
Morning, Judge.
Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Ms. Plescia.
Okay. By whom are you employed and in what capacity?
I'm employed by Brubaker and Associates as president.
And what is your business address?
16690 Swingley Ridge Road, Chesterfield, Missouri, 63017.
Are you the same Mr. Brubaker that caused to be filed in this case Exhibits 300, the rebuttal testimony of Morris Brubaker, Exhibit 301, sir, rebuttal testimony?
I am.
Do you have any additions or corrections to that testimony?
I do not.
I would go ahead and submit that the testimony be put into evidence.
And correct me if I'm wrong, but that would be Exhibits 300, 301, and 302, correct?
No, actually, I think there's just rebuttal and sir rebuttal.
Okay. Oh, I'm sorry.
So, yeah, we have Mr. Sherman as the
Right.
the last one.
Right. Is there any objection to the admission of 300 and 301?
Okay, then I'll tender the witness for cross.
All right. Exhibits 301 and 300 are admitted.
Your Honor,
Yes.
would it be a good time for me to go ahead and ask that Mr. Sherman's testimony, go ahead and, that we go ahead and put that in the record, unless somebody has an objection?
All right. That is actually Exhibit 302. So is there any objection to that testimony coming into evidence? Hearing none, Exhibit 302 is admitted. All right, Mr. Lowry or Ms. Grubbs, would you like to cross-examine the witness?
Thank you, Your Honor. Mr. Brubaker, in your direct testimony, which has been marked as Exhibit 300, you described the RSP rates, the Renewable Solutions Program rates, as an overlay on top of subscribing customers' existing regular tariff rates, correct?
That is correct, yes.
So just to be clear, by that, do you mean that the subscribers are always going to pay at least their regular tariff rate?
Yes, that's correct. The regular tariff rate remains in effect, and subscribers pay that rate. And then in addition, I call it an overlay because it's in addition to the regular tariff rate. So they pay that as well.
Those are all my questions for now.
All right, thank you. Mr. Brubaker, could I get you to move your mic a little closer to you? Thank
You
you.
have the same problem as staff council had yesterday. Is that better? Is that all right?
Yes,
Okay,
that is
sorry.
improved.
Thank you.
Thank you. All right, Mr. Opitz, do you have any questions for the witness?
Briefly, good morning, Mr. Brubaker.
Good morning.
In the discussion you just had, talking about paying the overlay charge for this RSP program, you represent several subscribers to this program, is that correct?
Yes, that's correct.
And can you tell me what the value to those subscribers is from participating in a program where they're paying an additional charge for?
Yes, the value that customers see in the program is that it gives them access to renewable attributes that are associated with the generation of renewable energy. And it's an intangible, it's an attribute that's been created in the marketplace, but it allows those customers to use those attributes to satisfy their renewable energy goals in terms of reduction of greenhouse gas emissions. So it's very valuable to them, and it's very helpful to have it offered by the local utility, just because the local utility is better able to construct and manage those facilities than are most customers.
And is there a value to the non-subscribing customers of Ameren, Missouri, due to the fact that commercial and industrial customers have subscribed to this program?
Yes, there's an economic benefit because the revenues from this program are a credit to the cost to be paid by the non-subscribers. So that's a major benefit. It's the renewable attributes, as I said, are an attribute. They are produced at zero cost. So what really happens is that the subscribers pay a cost that they're willing to pay in order to have the attributes, and then the revenue from that acquisition goes to offset the rates that everybody else pays.
And you were in the hearing room yesterday, correct?
I was.
And do you recall some of the discussion, and I can't remember the witness now, but about whether the subscriber rate was competitive or not competitive enough? Do you recall that discussion?
I do.
And I guess what is your view about the rate that the subscribers are paying?
Anytime you can charge something for something you produce for no cost, it's a good deal, I think. And that's exactly what we have here. There's no incremental cost to produce the RECs. And so starting off, it's a positive benefit. There was discussion about maybe Ameren could sell those in the marketplace. Right now, last I looked last week, the going price for RECs would be comparable is like $2 a megawatt hour, which is quite a bit lower than what the subscription price is. So I think it's a reasonable outcome.
That's all the questions I have, Your Honor.
All right, thank you. Mr. Thompson, do you have any questions?
No questions, Your Honor.
All right, Ms. Greenwald?
No questions, Your Honor.
All right. Mr. Williams?
Not at this time, thank you.
Mr. Graham? No, sir. All right. I do have, well, actually, Chairman Roop, do you have any questions? Do any of the other commissioners have questions? Okay. So I do have a couple of questions, Mr. Brubaker. If I can direct your attention to your direct testimony, page 6.
Yes, sir.
All right. Now, the renewable resource charge is essentially the subscription price for a subscriber, correct?
Correct.
Okay. On page 6 in your direct testimony, you assert that that due to improved economics resulting from the change from the investment tax credit plan to the production tax credits plan, that it would result, that it would result in improved economics that should pass through to the subscribers. Is that maybe I'm kind of
Essentially,
clumsily saying this.
let me try.
Yeah.
Basically, I was recognizing that the pricing for the subscription charge in the first place was tied to the cost of the project.
Okay.
And so when the cost of the project came down, I thought it would be equitable to recognize that in the level of the subscription charge. That was the basis for that recommendation.
And so do you still maintain that same position today?
Subject to what the final economics of the project are. If it turns out that the economics of the project are going to go above what the original charge would have been, then no, I would not be there.
Okay. Now, like you said, you were here yesterday and heard testimony that project costs have increased, correct?
Correct.
And so should those increased project costs pass on to the subscribers?
I don't think automatically, because the subscription price, although tied initially, the basis for the contract is those charges. And so it's really a kind of an obligation on the part of both parties to honor that. And since it's not based on cost of service, but based on what people will pay for them, I thought it would still be equitable to recognize that unless the cost of the project goes up above what it originally was.
Who, in your opinion, I say who, should cover those increased project costs? Would it be the ratepayers?
The ratepayers. The ratepayers get all the direct benefits. The ratepayers get the capacity value and the energy value out of the project. The subscribers are only getting the intangible benefits in the form of the renewable attributes, which are produced at zero cost.
Okay. Thank you. That's all the questions I have.
Yes, sir.
Ms. Grubbs, do you have any recross?
I do not, thank you.
Do any of the other parties have any recross? All right. Hearing none. Ms. Plescia, do you have any redirect?
Yes, I do. Mr. Brubaker, could you describe your understanding of the level of demand among subscribers, or would-be subscribers to this program?
I'm objecting to that because I believe it goes beyond the scope of any cross-examination or inquiry by the commission.
Mr. Opitz.
Oh, I'm sorry.
I'm sorry. Mr. Opitz
Hold on,
brought
Mr.
up.
Graham?
Oh, I'm sorry.
Staff joins that objection.
All right.
Mr. Opitz brought up the idea.
Just a second, Ms. Plescia.
Sure.
Mr. Graham, I'll direct your attention to your microphone. There you go.
I was just responding to the enthusiasm of counsel behind me and trying to get her question in. I didn't have time to get the mic down. I join in the objection. Staff joins in OPC's objection. Thank you.
All right, Ms. Plescia.
Mr. Opitz asked Mr. Brubaker some questions about the value of the program to the subscribers, and I think that might goes directly to the value issue.
I'll allow it for that limited purpose.
Thank you.
Would you mind repeating the question?
Sure. Could you describe your understanding or recollection of the level of demand that there was for the RSP in terms of subscribers that you're aware of?
The program is oversubscribed.
No other questions.
All right. Thank you, Mr. Brubaker.
Thank you, sir.
Thank you for your patience.
Thank you for yours.
Ms. Plescia, do you have any other witnesses to call?
No, thank you.
All right. Mr. Opitz, call your first witness.
Your Honor, Walmart calls Mr. Andrew Teague to the stand, and he is testifying virtually. I believe
Okay.
he's online now.
All right. Okay. I see that he is on our feed. So, Mr. Teague, good morning.
Morning.
Would you raise your right hand to be sworn in, please? Thank you. Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Teague, can you state and spell your name for the record?
Andrew Teague, Andrew Teague.
And where are you employed and in what capacity?
Walmart as a senior manager.
Did you prepare pre-filed testimony in this case that has been pre-marked as Exhibits 400, the rebuttal testimony of Andrew Teague, and Exhibit 401, the surrebuttal testimony of Andrew Teague?
I did.
Do you have any corrections to that testimony?
I do not.
If I were to ask you the questions posed in those documents today, would your answers be the same?
Yes, they would.
And the information contained therein is true and correct to your knowledge and belief?
Yes, they are.
Your Honor, at this time, I'd offer Exhibits 400 and 401 into the record.
Are there any objections? Hearing none, Exhibit 400 and 401 are admitted into evidence.
And I would tender the witness for cross-examination.
Okay. Would it be Ms. Grubbs?
Yes, thank you, Your
All right.
Honor. Mr. Teague, are you familiar with the company's proposed Renewable Solutions Program rider tariff?
Yes, I am.
And you had in testimony described a potential concern about needing to add a provision to the tariff that clarified that renewable energy credits, or RECs, would be retired on behalf of subscribers. Do you recall that?
Yes, I do.
So if we look at sheet number 83.3 of the proposed tariff, do you have that available? And I will represent for the record, it's EFIS exhibit or item number 11 in the docket.
I do, yes.
Okay. So if we turn to sheet number 83.3, about halfway down the page, there's a subheading that says Other Program Provision and Terms. Do you follow me?
Yes, ma'am.
And the second provision under that reads that the RECs, R-E-C-S, associated with the generation output of currently subscribed program resources will be retired on behalf of subscribed customers and shall not be used for any other purposes during the term of subscription, including for the companies complying with RES requirements. The program is considered a voluntary program unrelated to compliance with RES requirements. Therefore, the Commission is not actively monitoring the retirement of RECs or allocation amongst customers. Did I read that accurately?
Yes, you did.
So is there anything additional that then you would add or alternate language that you would propose for that provision to address your concern?
No, that's sufficient.
Okay. Thank you very much for your time. That's all I've got right now.
All right. Ms. Palacio, do you have any questions for the witness?
No questions.
All right. Mr. Thompson?
No questions, Your Honor.
Ms. Greenwald?
No questions, thank you.
All right. Mr. Williams?
Not at this time, thank you.
Mr. Graham?
No.
All right. Chairman, do you have any questions? Any of the other commissioners have any questions? All right. Hearing none, I do have a couple of things, Mr. Teague. For large customers, such as Walmart, what options are available to meet your renewable and carbon-free energy goals?
Oftentimes we'll partner with utilities or engage in power purchasing agreements. Those are the two main ones. We're also looking at ways to build out renewable energy ourselves.
Okay. Is it possible for large customers to simply purchase renewable energy credits to satisfy their renewable and carbon-free energy goals?
In some cases, yes. Walmart, however, is trying to acquire green energy without any offsets.
I'm sorry, can you repeat that, the last part of that sentence?
Walmart is trying to sorry, I'm getting some feedback. Walmart is trying to acquire green energy without any offsets, so RECs may not be sufficient in that case.
Okay. In this particular, for this particular project, are you aware that the solar panels themselves will be located in Illinois? Whereas,
I am, yes.
Oh, I'm sorry.
Sorry.
And what was your answer to that?
I am, yes.
Okay. Would Walmart prefer to have the energy produced in the state that it's located in rather than in a neighboring state?
That would be preferential, yes.
Why is that?
We would rather we do prefer to have a direct location of the energy with where it's to be consumed.
Is there some corporate policy behind that?
If there is, I'm unaware of it.
Okay. Are you aware that the staff of the commission has suggested that large customers could install their own solar resources, I think what is referred to as behind the meter renewable energy, and the Boomtown project isn't needed? Is Walmart in a position to install its own solar resources?
There are cases in which we are unable to install the solar resources ourselves.
But there are cases where you are able to?
There are, but they would not be sufficient to satisfy our needs.
Do any of the Walmart stores in the country have its own solar generation resources?
Yes.
How many were we talking about?
I do not know the number off the top of my head, but I think the number is at least in the hundreds. Okay.
And without going too far off track, are these situations where these solar panels, is it solar for one thing?
In the majority of the cases, I do believe it's solar.
Okay. And is it a situation where those solar panels are located on the roofs of your stores or on the ground nearby, if you know?
I believe we have both roof-mounted and outlying areas with solar panels.
Okay. But those would all be considered behind the meter?
Yes.
Okay. All right. Those are all the questions I have. Ms. Grubbs, do you have any recross?
No, thank you, Your Honor.
Anyone else? All right. Hearing none. Mr. Opitz, redirect?
Very briefly, Mr. Teague, the judge was asking you some questions about Walmart's methods of procuring renewable energy. Do you recall that?
Yes, I do.
And is it your understanding that a PPA is not an option for your stores in Missouri?
That is my understanding.
And when Walmart procures renewable energy for its stores, that process is generally location-specific or jurisdictional-specific. Is that correct?
That's correct.
And in this case, Walmart has elected to subscribe to the RSP program.
That's correct.
That's all the questions I have, Your Honor.
All right. Excuse me. Okay, Mr. Teague, thank you for your testimony.
Thank you.
Okay, and my understanding, Mr. Opitz, is that that is your only witness?
That's correct, Your Honor. Mr. Teague was Walmart's only witness in this
Okay.
case.
All right. Then I believe Mr. Thompson for the Sierra Club, call your first witness.
Your Honor, we call Sarah Shenstone Harris. She should be participating via WebEx.
Okay. And I do see that she's on the WebEx feed. Ms. Shenstone Harris, would you raise your right hand, please, to be sworn in? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Thompson.
Ms. Shenstone Harris, would you please state and spell your name for the record?
Sarah Shenstone Harris. That's S-A-R-A-H. And the last name is S-H-E-N-S-T-O-N-E-Harris. H-A-R-R-I-S.
Could you please state your employer and its business address?
Yes, Synapse Energy Economics, and that's at 485 Massachusetts Avenue, number 3 in Cambridge, Massachusetts. And the zip code is 02139.
Ms. Shenstone Harris, did you cause to be filed in this matter sir rebuttal testimony which has been pre-marked as exhibit number 500?
I did.
Do you have a copy of that sir rebuttal testimony in front of you?
Yes.
For that testimony, were you asked a series of questions to which you provided answers?
I did.
Were all the answers that you provided true and accurate?
Yes.
Did you have any corrections to your testimony?
No.
If I asked you the same questions today, would your answers be any different?
They would.
They would?
Yes, they would.
They would be, sorry, can I repeat that question? If
Sorry, I misheard.
If I asked you the same questions today, would your answers be any different?
Oh, no, they would not. Sorry.
Okay, thank you, Ms. Johnson Harris. With that, Your Honor, I would like to enter into evidence exhibit number 500.
All right, is there any objection to the admission of Exhibit 500? All right, hearing none, Exhibit 500 is admitted.
And with that, I can tender the witness for cross-examination.
All right, for Ameren? No questions, Your Honor. All right. Ms. Pleshia, any questions? No questions, Your Honor. Any questions from the other parties? All right, hearing none, I'll turn to the commissioners. Chairman, do you have any questions? No, I don't. Thank you much. Do any of the other commissioners have questions for this witness? I don't have any questions myself. So, Ms. Shenstone Harris, we take your testimony.
Pardon me?
I said there are no further questions, so we do appreciate your testimony, and you're excused from the hearing. Thank you. All right, Mr. Thompson, that is your sole witness, correct?
Yes, Your Honor.
All right. Then that brings us to witnesses for Renew Missouri. So, Ms. Greenwald, call your first witness.
Renew Missouri calls Mr. James Owen.
Good morning, Mr. Owen.
Good morning.
Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead.
Mr. Owen, will you please state your full name for the record?
Yeah, my name is James Matthew Owen, O-W-E-N.
By whom are you employed and in what capacity?
I am the Executive Director and Officer of Renew Missouri Advocates Incorporated.
Did you prepare and cause to be pre-filed rebuttal testimony that has been marked as Exhibit 600?
I did.
Do you have any changes to make to your testimony at this time?
I do not.
And if I were to ask you those same questions today, would your answers be substantially the same?
They would.
And are all of those answers true and correct to the best of your information, knowledge, and belief?
They are.
At this time, I offer Exhibit 600 into evidence.
Okay. Is there any objection to the admission of Exhibit 600? All right. Hearing none, Exhibit 600 is admitted.
And I tender the witness for cross.
All right. Any Ameren?
No, thank you, Your Honor.
All right. Any cross on behalf of the Missouri industrial energy consumers? All right. From Walmart?
No, thank you, Your Honor.
From the Sierra Club?
No questions, Your Honor.
And from Public Counsel?
Not at this time, thank you.
And from staff of the commission?
No, thank you.
All right. Do any of the commissioners have any questions for this witness? All right. Then I don't have any questions myself. So, Mr. Owen, you may step down.
Off the hook. Thank you.
All right. Does anyone need to take a break at this point? Yeah. Okay. All right, then we are at the point where we will take testimony from the Office of Public Counsel's witnesses. So, Mr. Williams, your first witness.
Public counsel calls Dr. Jeff Mark to the stand.
All right. Dr. Mark, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony given in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
What is your name?
Jeff Mark, Geoffmarke.
By whom are you employed and in what capacity?
I'm employed by the Missouri Office of Public Counsel as the chief economist.
And did you prepare what's been designated as rebuttal testimony and surrebuttal testimony that were pre-filed in this case on December 21st of last year and January 18th of this year, respectively?
Yes.
And does that surrebuttal testimony include some highly confidential information?
Yeah.
For that testimony to be your testimony here today, and by the way, that's been marked as Exhibit 200 for purposes of this hearing, would you have any changes to it?
No changes to my rebuttal testimony.
And with regard to your surrebuttal testimony, would you have any changes to it for it to be your testimony here today?
I do.
Would you go through and identify the page and line number and otherwise describe sufficiently so someone can follow where your changes are?
Sure. So going off of the highly confidential version of my testimony, surrebuttal testimony, page 6, footnote number 2, it reads MISO 2022, Managing Reliability Risk in the MISO Footprint, June 16th, 2022. That should read 2022. On page 10, line 6, the answer says not for zone 4 through 7 as seen in figure 3. It should read not zones 4 through 6 as seen in figure 3.
And for purposes of the record, that testimony has been, your surrebuttal testimony has been assigned to exhibit number 201 HC. With those changes are Exhibits 200 and 201, your testimony here today?
I've actually have two more changes.
Well, okay, go forward with your other changes then.
Okay. Page 12, line 3 says, question, why does figure 3 show zones 4 through 7 as having deficiencies? It should say, why does figure 3 show zones 4 through 6 as having deficiencies? And then on page 15, the answer set on line 5, it says, only in the most general sense. The first immediate issue is that the 200 megawatt nameplate, and that should read 150 megawatt nameplate. In line 6, it says capacity would only initially be accredited at 70 megawatts, and that should now read 52.5 megawatts.
Do you have any other changes?
I don't believe so.
And with those changes, are Exhibits 200 and 201 your testimony here today?
They are.
I offer Exhibits 200 and 201.
All right. Excuse me. Are there any objections to the admission of 200 and 201? All right. Hearing none, Exhibits 200 and 201, both the public and highly confidential versions of 201, are admitted into evidence.
I offer the witness for cross-examination and querying by the commission.
All right. Mr. Graham, do you have questions on behalf of the staff?
Yes, Your Honor. Good morning, Mr. Markey.
Good morning.
Considering only the construction activities of building Boomtown, located in eastern Illinois, there won't be Missouri economic benefits, including local taxes, property taxes, job, and that sort of thing. Is that a correct statement?
Yes, it is.
Do you think that the Ameren IRP, including the planning assumptions, are objective?
Oh, that's a difficult question to answer.
Try again, then I'll withdraw that question.
Okay.
Do you think that those planning assumptions are devoid of bias?
No.
Can you explain?
So Ameren, Missouri I'll give you an example. Ameren, Missouri had contracted out with two separate third-party vendors, one to look at bringing on an aggressive amount of renewables, and another to look at the reliability consideration. If you were to go into the IRP, the triennial IRP, you would see a copy of the renewable third-party study. There is no copy of the reliability study within that IRP. It's a modeling exercise, and any modeling exercise is going to be dependent on the inputs that go into it. I'll give you an example, I think, of bias that's inherent within the IRP modeling right now. We've heard the term levelized cost of energy, LCOE. This is a term that we compare like resources across the board. So wind, solar, gas, nuclear, the all-in cost assumptions, including tax credits that are associated with that. The problem with that is that it doesn't take into account the value of the energy. And what I mean by that is, provide an analogy. If I said there was a metric out there called levelized shelter, and it was only trying to capture how dry you would be from having shelter. And it looked at various different shelter costs. So a mansion, a house, an apartment, a shack, a tent, an umbrella. If we were to look at all of those, the levelized cost of shelter across all of those, one would surmise that, well, umbrellas would be the cheapest way to go, and we'd fit it out with umbrellas for everybody. The levelized cost of energy functions in a very similar manner. It looks at the energy within an isolated silo. And what we've seen from presentations from MISO, from the press, concerns about reliability issues is that accredited capacity matters. Being able to call on that energy and ramp it up has an intrinsic value that's not captured in the levelized cost of energy. I'm familiar with a term called LACE, levelized avoided cost of energy, recently as a potential metric moving forward that could provide a little more nuance into the IRP. But absent that, and that's where we're at right now with Ameren's IRP, absent that, it distorts the outcome that you get.
Step further with that. Would you agree that when we're speaking of bias in this context, we are with a company from a range of assumptions that can be made? When we speak of bias, we are choosing the assumptions that direct the model in the direction we want it to reach, the conclusion we want it to reach, and specifically a shareholder or company favored result. Is that what you mean by bias?
Your Honor, if I could interpose an objection at this point, and the objection is that this is improper cross-examination, and I'd ask to be heard on the basis for that objection.
Go ahead.
So Ameren, Missouri, of course, bears the burden of going forward and the burden of persuasion in this case, as everybody would agree. And I think everybody else would also agree, and the record would reflect that staff and OPC are opposed to the project and the program, in many cases on similar grounds. Now, certainly, folks have a right to cross-examine witnesses, but what they don't have a right to do is to examine each other's witnesses in a way that's not adverse to their own positions to bolster their case. In fact, the Missouri law, the State Rail Consumers Council case that involved a commission decision itself, indicates that the purpose of cross-examination is to elicit information favorable to the view of the examiner and unfavorable to the position of the party of the witness being examined. Staff's questions are clearly designed to elicit information that's favorable to staff's and OPC's position as opposed to amounting to actual cross-examination. And the construct here is that we can cross-examine each other's witnesses. The construct is not that we can bolster our cases by using each other to put things in the record that weren't put in the record initially. I think it violates these due process rights. I think it violates the purpose of cross-examination. I think it violates the commission rules that require that their testimony, their rebuttal testimony in a case like this, include all reasons that they oppose the proposal before you or alternatives to the proposal. The reason we get to file rebuttal last is because we have the burden of proof, and that's the way it works. But I think this is improper cross-examination. I can see that Mr. Graham has a whole line of questions here that I'm confident are designed to bolster staff and OPC's opposition. I think it's improper cross-examination.
Mr. Graham?
It seems to me that Ameren has crossed all of the other witnesses favorable to its position here with a view towards developing its own case. None of those questions appeared to this council at least to be creating or exploring an adverse situation between Ameren on the one hand and the witness being cross-examined. I would add I heard council bring up a due process argument to deny the staff the opportunity to cross this witness in any way deemed to help the position of the staff and to help specifically the understanding of the commission would be to deny staff due process, a right to confront the witness, and deny the commission the opportunity to look at all of the facts. Adding the answers that I anticipate coming from this witness to this question have not been provided to my recollection by any other witness or any other testimony filed in the case. In that respect, it advances the cause of making a decision by the commission in this case.
Two quick points, if I could, Your Honor. I think Mr. Graham just made my point. This information they expect to elicit has not been provided by either of them in response to the application. And they're also admitting that they're seeking to elicit testimony that is not unfavorable to the witness that's being examined, but that's actually favorable to the witness that's being examined, which is not cross-examination. There's no of the right to cross-examine. If they want to cross-examine, they can. But what they can't do is essentially conduct a direct examination under the guise of cross-examination.
All right. I agree with that, and we'll sustain that objection.
Could I ask the court reporter, Your Honor, in connection with making an offer of proof, to read my question back?
Sure.
Would you agree that when we're speaking of bias in this context, we are from, or the company from a range of assumptions that can be made? When we speak of bias, we are choosing the assumptions, the direct model, and the direction we want it to reach, the conclusion we want it to reach, and specifically a shareholder or company favored result. Is that what you mean by bias?
Now, Your Honor, I anticipate the witness's answer will be yes. And furthermore, I would direct the Commission's attention to the fact that I was asking for a general definition of bias, and as a general definition of bias, the question was itself not biased in the direction of any party, including staff.
Your Honor, I completely disagree with that characterization. He basically asked a question that says, wouldn't the company bias their modeling in favor of the result that the company wants and in a way that would favor shareholder interest, which is exactly one of the arguments that staff has made in this case. They're trying to elicit testimony to bolster their own case from this witness, and they say they expect him to do that. That's not cross-examination.
Your Honor, Ameren has restated a new question which I did not ask. The court, the judge, the Commission has heard from the court reporter exactly the question that I asked. I did not ask the question that Mr. Lowry says I asked, and I won't.
All right.
I'd ask the judge to reconsider his ruling.
My ruling stands, Mr. Graham. Move on with your questioning.
Thank you, Your Honor. In connection with IRPs and as a matter of procedure with respect to IRPs, to your understanding, do other parties have meaningful opportunities to materially alter the planning assumptions that go into an IRP?
Same objection, Your Honor. One of the staff's positions is that they don't, and they are asking this witness to agree with the position that they have taken in this case, which is not adverse to the staff's or the witness's interest.
I'll sustain the objection.
Your Honor, I would ask you simply, or the Commission simply, to note the prior offer of proof that I made and take it as an offer of proof with respect to this question. And I will tell the Commission that I anticipate that the answer to this question will be no.
All right, so noted.
All right. Mr. Markey, is it correct that this is a facility that has a nameplate capacity of 150 megawatts?
Yes.
And the subscriber's fixed charge is based upon a percentage of those megawatts?
That's correct.
Now, Ameren stated that they had binding commitments for 269 megawatts and a wait list. Is that right?
That's correct.
You are chief economist for the Office of Public Counsel. Is that right?
That's correct.
If an entity is putting out a product for market and more people want to purchase the product at the price you established, doesn't that create a shortage?
Yes.
And shouldn't the price be increased to meet the demand?
Objection, Your Honor. Again, what the staff is doing here is staff opposes the program, and they are drawing the inference, or attempting to through this witness, that the price is too low, and therefore the program is unfair and should be denied for that reason. It's exactly the same angle of trying to bolster their own case and not asking a question that's adverse to this witness. It's not cross-examination.
You know, feel like that is information that would be useful to the commissioners, so I'm going to overrule your objection. You can answer the question.
Do you need the question restated?
I do, please.
If an entity is putting out a product for market and more people wanted to purchase the product at the price you establish, doesn't that create a shortage that shouldn't the price be doesn't that create a shortage?
Yes.
And shouldn't the price be increased to meet demand?
Yes.
Doesn't the excess demand for the RSP indicate that there may have been a higher price point that participants were willing to pay for the opportunity to lock in RECs and receive the public perception benefit of appearing to move towards renewable energy?
Same objection, Your Honor.
I'll overrule that objection. You can answer the question.
I believe it presents two insights. First of all, yes. Having the price lower and having a demand greater suggests that you could bring the price up to meet that demand. But it also suggests that the threshold of participation is too low. And if you have 10 participants, there is no reason why we couldn't extend that further with further participants, which would ultimately benefit both shareholders and non-participants and the participants themselves.
I don't want to go past this question. I mean, I can try it, but I'll sustain the objection to that. And he's going in our direction now. Mr. Markey, were you a witness in docket number EO-2022-0061?
Yes.
Can you provide a brief explanation of what the subject of that docket was?
Mr. Graham, could you tell me what utility? Actually, I should be able to pull it off my. If you have it readily available, that would be appreciative.
Evergy, Missouri West.
And
Velvet Tech.
yes.
All right. Can you provide a brief explanation of what the subject of that docket was?
Velvet Tech is a processing center that wanted to locate in the greater Kansas City area, and they were looking for a special high voltage rate for its services that was tied to in a renewable attribute power purchase agreement with the company Evergy West. So the docket revolved around setting up a tariff to conform to that respective customer.
Are you aware of any Missouri customers that are quote-unquote served by or expect to be served by a dedicated PPA?
Yes.
That concludes staff's questions.
All right. If it's acceptable to everyone, let's take a break at this point and reconvene after 10. So let's go off the record. Mr. Opitz, do you have questions of the witness?
No, thank you, Your Honor.
Ms. Johnson?
No questions, Your Honor.
All right. Ms. Greenwald?
No questions, Your Honor.
Ms. Pleshia? No questions, Your Honor. Mr. Lowry?
No questions, Your Honor.
All right. Chairman, do you have any questions for this witness? Okay. Any of the other commissioners have questions?
No questions, Judge Holzman.
Thank you, Commissioner. All right, I've got some questions myself. If you know, how many annual renewable energy credits will the Boomtown project have?
I don't know.
Okay. I think you... I'm sorry, go ahead.
But to say, in part, it's going to be dependent on how productive it is.
You were in here earlier when Mr. Brubaker testified that something to the effect that the current market rate for RECs was $2 to $3 per megawatt hour.
Yes,
Would you agree with that?
I would.
How do you have any opinion as to what that market value might be in the future?
It will be diminished. Mr. Wills talked about this at length yesterday, too. There's just more of a supply that's going to be placed.
Okay. Besides the entire supply and demand in the entire marketplace, is there any connection between the value of the RECs and the life of the solar panels, the project itself?
I guess the connection would be the difference for the participants, that they would be locked into a particular rate for the life and know that there's an expected life of that asset.
If the commission were to approve only the CCN and not the renewable, I'm sorry, I'm going to have to look it up to make sure I get it right, the Renewable Solutions Program, the subscription-based program, would those RECs be owned by Ameren, Missouri?
Yes.
Okay. And would you agree with testimony we heard yesterday that those could be monetized?
They could be.
Okay. Would it be the normal practice to sell those RECs every year?
That's a great question. That is the position for our office, and my understanding is both for the PSC staff as well. That hasn't always been the practice with some of our utilities, but to my knowledge, Ameren, Missouri has sold their access when they've had them.
Okay. When you look at Ameren's current situation for capacity and their needs in the future, when do you believe that Ameren, Missouri will need additional capacity to meet its customers' needs?
It's a very good question. Right now, I have a lot of concern about that moving forward. Based off of the most recent integrated resource plan, and my testimony goes in at length about the additional renewables coming in at an accredited capacity being much smaller than the nameplate capacity, suggests that there's going to be a deficit in resource adequacy. There was last year in 2022. There's every reason to believe there's going to be a resource deficiency in 2023 and moving forward, because my understanding is, as of right now, there's nothing in the interconnection queue right now outside of solar and wind within Zone 4. So all of those present a potential challenge, especially if Rush Island goes down when we plan it for it to go down. This also brings up frequency and voltage issues as well as secondary concerns. 2031 is when the company has put forward tentatively in their plan that they're going to produce a combined combustion cycle gas plant, a very large one.
Mm-hmm.
I've got concerns about that. I mean, quite frankly. The commission had the opportunity to listen to representatives from MISO back in August, about 6 months ago, that articulated the concerns surrounding resource adequacy. That MISO representative also spoke about the reality that there is going to be more solar and wind resources moving forward need to be more adaptive, more complementary to the grid itself. The big problem, as I see, Your Honor, is historically we've looked at IRPs largely in a vacuum. This is what's taking place with Ameren. This is how much load they need to meet, what we need to plan for in the future. And now it's so dependent on what's taking place in the market itself. So the actions of Illinois absolutely have an impact on what's taking place in Missouri. The actions, the deficits in other regions. So the big concern is not just where Ameren's at, but if you have a continued retirement of fossil fuel generation and baseload generation, then all of a sudden relying on the market to meet our resource adequacy needs becomes a real problem.
And at the beginning of your answer to my question, you referred to Zone 4. So Zone 4 is roughly Illinois, correct?
Zone 5.
Okay, so you meant
Zone 5.
You meant Zone 5,
Right.
Okay. In your rebuttal testimony, you state that Ameren, Missouri will be short capacity of approximately 2,200 megawatts by 2030 using MISO's accredited capacity percentages, correct?
That's correct.
Okay. Using MISO's accredited capacity percentages, will the company still be in a capacity shortfall in 2045, which is the latest year of Ameren, Missouri's preferred resource plan?
So my answer to that is I don't know. I would put forward that it's so far into the future that the accreditation numbers are going to change, the technology is going to change. It's our level of assurance beyond 5, definitely beyond 10 years is a best educated guess. My testimony spoke at length about a phenomenon of the devaluation of renewables. So as more solar and wind on, it tends to cancel each other out. And that's a very real concern. Typically it's about 30%. This number I've been quoted of renewables where you see diminishing returns off of each incremental renewable that's placed on. At a high level, that just means that accredited capacity will probably be even lower.
Are you saying 30% of the entire capacity of all utilities?
Within that grid. So 2 examples that I would give, like real world examples where you can see this. One is in Casio, the state of California. Just Google the duck curve. You can see the impact that has had on their prices. The other one is in SPP right now, where you've had such an increase in the amount of wind that my understanding is SPP is moving towards a performance-based accreditation. So they're going to base the accredited capacity of their units based off of its actual performance.
And when you say SPP, you mean Southwest Power Pool?
Yes, I do.
Okay. In your rebuttal testimony, you recommend that the commission deny Ameren, Missouri's request for a CCN. Is that right?
Yes.
But would you agree, though, that if the commission were to approve this CCN, then it would somewhat address the capacity shortfall issue?
So, and I addressed this in my SUR rebuttal, and So Mr. Wills isn't wrong when he says, and I think he posits the situation is, I can't imagine a situation where customers wouldn't be better off with this. But that presupposes that the only option is a bilateral option. It's either do it or don't do it. And what I would suggest is, no, you could do the solar in Missouri. You could at least get the resource capacity there. There's a number of other options. You could have the solar conform to the green tariff option that we had walked through in cases where there's clearly a demand for the product. You have a number of commercial and industrial oversubscribed is the phrase. Why not have all of those oversubscribed participate in this? And all of a sudden, the cost of this overall project and the risk borne by participants is diminished considerably.
And you were here yesterday for all the testimony, correct?
It was.
Okay. And so there was testimony about how the project costs have increased from Ameren's initial estimates. How do you think those project costs affect the tax mechanism, the tax credit mechanism that might be used?
Your Honor, it might be appropriate for me to go off camera for this if I want to speak to the
All right.
numbers a little bit.
All right, give me a second on that. Yes.
Your Honor, if you could repeat the question.
Given what you just testified to in camera, do you Do you consider the project economically feasible?
I don't.
All right, would you like to elaborate on that?
So my concern is we don't know the cost of the project right now. So we have every reason to believe that it's going to increase in cost. Additionally, my concern is the value of the project moving forward. In terms of the revenue that we can get from it, as well as valuation, more renewables come online. Admittedly, I have not gone down the path of looking at the new numbers within the context of available resources that could be procured. For example, the Ameren RFP that took place, I know listed a number of different options. So all of that would need to be considered.
If I want to kind of take a step back, do you have any opinion on the two tax credit programs, the PTC versus the ITC?
I do not believe I could speak well on either of those topics.
Okay. I believe it was in your pre-filed testimony that you testified that a 50-50 cost risk sharing mechanism would be appropriate for the commission to consider. Could you talk about that for a minute?
The 50-50 risk sharing mechanism is a tariff, the impetus behind a green tariff agreement with stakeholders in Ameren, Missouri, Evergy, Missouri West, Evergy, Missouri Metro, and I believe Empire District Electric as well for their commercial customer programs. The 50-50 sharing mechanism provides a resource need for customers that want to pay for it. So we clearly know that there are customers out there that want to take advantage of renewables, the RECs, additionality, emissionality, all of those factors in choosing their location. This allows that to function. But it also allows an assurance to non-participants that if that program becomes undersubscribed, that those costs are borne equally between ratepayers and shareholders in terms of risk exposure. The reality of it is companies go bankrupt. Municipalities go bankrupt. Heaven forbid that doesn't happen, but if it does and there is that opening there, it's a recognition of both shared cost and shared benefits. In this case, I know it's been put forward in a number of ways that non-participants get all the benefits from this, and I would take issue with that. I mean, clearly, this gets put in rate base. They're able to earn a return off of this asset too. So having a 50-50 sharing mechanism is a sanity check to make sure that we're just not, you don't have just an absurd situation where you might have one customer sign up for a lot of renewables and then back out the next day after it's been built.
And to your knowledge, has the commission considered a similar mechanism?
They have. The commission has approved a 50-50 sharing mechanism across our electric utilities. And this, what I found in my rebuttal testimony, misunderstood this to a greater extent and addressed it in my rebuttal testimony. But that's what was disconcerting about the renewables program, is that Ameren has effectively said, we're not going to do that anymore. We're just going to go ahead and have 10 customers go ahead and chip in a few bucks and bring the overall cost of this down a little bit.
Okay. I want to shift gears a little bit and ask you this question. Do you have an opinion on the effect of this project from an economic development perspective?
Sure. For Missouri specific, I don't believe there is one. I mean, this is taking place in Illinois, and any sort of tax credits or tax, typically when you cite a renewable project or really any generation resource, There's negotiation that takes place at the local level. Sometimes that extends to the state level. But that's all taking place in Illinois, and I can't remember the county's name off the top of my head.
I believe it's White County.
White County. In terms of, attracting customers that may be interested in this, I would say right now Ameren has a green tariff available. It exists. It's on their books today. There is no reason, that any of the customers, Walmart or Bear or anybody else, can't move forward with the tariff option that exists. If the company has the tariff approved.
But with this RSP, as long as you as a company are a customer of Ameren, Missouri, in Missouri, would there not be benefits to that company to participate in the program?
I'm not disagreeing that customers want this and perceive that there's a benefit in participating in a renewable choice program. And I want to be clear, like, our office supports the idea of a renewable choice program for commercial customers. This is, again, support of the green tariff program. So there is a benefit. Where we take issue is just the design. We just feel like the design is now been heavily weighted towards risk exposure to non-participants. That's the biggest difference.
I take it you reviewed the proposed tariff.
Yes.
Does Ameren's existing renewable tariff program retire RECs on the customer's behalf so that they meet their ESG goals?
That's my understanding.
Okay. Okay, that's all the questions I have. All right, Mr. Graham, any recross on behalf of the staff?
Yes, Your Honor. In response to questions from the bench, you discussed resource adequacy. To your knowledge, has Ameren, Missouri demonstrated in this case how Boontown helps them meet their load in all hours?
Objection. It's not adverse to the interest of the witness. It's improper cross-examination.
I'm going to overrule the objection and allow the question.
No, they have not.
Thanks, Your Honor. That's all that staff has.
All right. Any other recross?
Yes, Your Honor.
All right.
Dr. Mark, the bench asked you some question about the effect on economic development, from an economic development perspective of the proposed project and program, did he not?
Yes.
A company with Missouri operations can subscribe and get the renewable attributes of the resource, is that right, as proposed?
Yes.
And then use those renewable attributes as credit toward meeting its renewable goals, correct?
That's correct.
And it doesn't matter whether the Ameren, Missouri owns the facility in Illinois or whether the facility's in Missouri or in Iowa or any other MISO state, they can still get the RECs and count those toward their renewable goals, isn't that right?
That's correct.
You discussed the green tariff program, the existing renewable choice program I think you're referring to, is that right?
That's correct.
Ameren, Missouri didn't justify adopting that tariff on the grounds that it needed to add renewables to meet its customers, its general body of customers' energy or capacity needs, did it?
No.
And the 50-50 sharing that is in place was a result of a stipulation that the company voluntarily agreed to on those facts, correct?
That's correct.
You gave the opinion here today that you don't believe that this project is economically feasible under the Tartan factors, right?
Yes.
But you've provided no evidence that the cost of the project will be above market for a similarly situated project in the market today, have you?
I have not.
You haven't presented an alternative project that would be more cost-effective, cheaper for a comparable project, capacity factor, et cetera, have you?
I have not presented one.
You don't know, for example, whether Ameren, Missouri could locate a comparable project or when it could do that, if it could. Is that right?
I have not.
You don't know how long it would take to do that and to then come back to the commission and get through the CCN process, do you?
I do not.
You don't know whether or not another project would, a comparable project could be located in an energy community and get a 40% ITC instead of a 30%, isn't that right?
That's correct.
Just to clear up the record, which zone is Illinois in MISO and which one's Missouri?
So Zone 4 is Illinois, Zone 5 is Missouri.
And you may have said that, but I thought it was backwards when you talked about it before.
I may have.
Ameren, Missouri has significant generation resources in Illinois today, right?
Today.
And has for quite some time, isn't that right?
That's correct.
You're not aware of there being any transfer capability problem, transfer capacity problems between Illinois and Missouri, are you?
I'm not.
The judge asked you some questions about if the commission only approved the CCN and not the program, would the RECs be owned by Ameren, Missouri? And you said yes, right?
Yes.
You also agreed, however, that prices, as Mr. Brubaker testified, are lower today than the implied REC price that the subscribers are going to pay under the program, under the contracts they've entered into, right?
That's correct.
And you also agreed with Mr. Will's position, opinion that REC prices are going to go down in the future. That would be your opinion as well, right?
That's correct.
So if the RECs are owned by Ameren, Missouri and produced year by year in a declining market, that's less than the cost the subscribers are going to pay. The revenues from the RECs are going to be less than effectively they're going to be through the program. Isn't that right?
That's correct.
I think some questions were asked about, or maybe you gave an answer at least, that was talking about the level of renewable penetration in MISO today, right?
Yes.
And you, I think, the threshold point where the study says one might expect to hit diminishing returns for renewables is about 30% penetration. Is that right?
That's correct.
The addition of a 150 megawatt solar facility, the Boomtown project, is not going to increase the penetration of renewables in MISO to anywhere near 30%, is it?
No, it will not.
Ameren's not basing the need for the Boomtown project on economic speculation, is it?
No.
You would agree that as part of the integrated resource, well, let me back up. The integrated resource planning process, would you agree it's an ongoing process?
Yes.
And at a minimum, the company has to file a full IRP every 3 years, right?
Correct.
And then annual updates every year, right?
Yes.
And special contemporary issues get suggested every year, and the company has to address those, right?
Yes.
Utilizing the IRP process, the company can check and adjust on the addition of renewable generation resources if MISO were to begin to reach a higher penetration, couldn't it?
Yes.
That's all the questions I have, Judge. Thank you.
All right. Mr. Williams, any redirect on behalf of the public counsel?
I'm afraid so. Dr. Mark, whenever you testified that your opinion that the project is not economically feasible, was that just based on comparable projects, or was it based on something else?
It was based off of comparable projects and looking at it through the lens of accredited capacity for the LCOE as compared to nameplate capacity for the LCOE.
And when you say comparable projects, you're talking about 150 megawatt solar projects?
Sure. Solar projects or demand response for example.
So comparables is broader than just solar projects.
Sure.
You used the word, I think it's levelized cost of energy, LCOE. What is that exactly?
That's the levelized cost of energy is a metric put forward to determine the valuation of energy across different resources. So solar resources, wind resources, natural gas, nuclear. It looks at the all-in cost associated with those generation resources and provides an overall number for comparison. Lazard is the
Well,
go-to.
you've hit the cost aspect of it. It's also related to energy, is it not?
Right, levelized cost of energy.
So if I understand you correctly, you're taking all of the costs that you assume this particular resource is going to have over its life, and you divide it by the energy you anticipate it's going to produce?
That's correct.
You testified, and I heard you say CAISO. Did you mean the California ISO, which is CAISO, C-A-I-S-O?
Yes.
Is a REC of indefinite length, or is there a life to a REC?
It has a defined length. So RECs can expire if they're not used or sold or retired.
Do you know what that life is?
Oh, I don't know off the top of my head. I think it's roughly about a year.
And are there different flavors of RECs?
There are. So you can have solar RECs or just renewable energy RECs.
And you mentioned for resource planning, the integrated resource plan and the market impacts. Would you explain more about the interplay there?
So the big concern, we know from 2022 where Ameren, Missouri zone was under its resource adequacy levels. The cost of new entry for bringing in that generation came in, I think, at like $236 a megawatt. And that's dependent on being able to get generation resources from other zones into Missouri. So the concern moving forward from an integrated resource planning perspective is that it's all interdependent. I mean, and that's one thing that I think we have appreciated much more over the last couple of years. Is in planning our generation mix moving forward from an IRP perspective to be cognizant of what's taking place everywhere else. Illinois, for example, has moved forward with legislation not to have fossil fuel generation in its state. That's going to have direct impact on Missouri, potentially positive, potentially negative, being able to supply resources into that zone. So what it does mean is that we won't necessarily be able to rely on Illinois. And we know that there's a number of peaker plants that Ameren has that will have to be retired or, if possible, moved. I'm not sure that is a possibility, but that's going to hit the overall resource adequacy moving forward.
And whenever you're speaking of economic feasibility, is that from a particular perspective, say from the utilities perspective, from the commission's perspective, from a customer's perspective?
I mean, I would say all the above. We need a healthy utility. We need to make sure that rates are just and reasonable and affordable. I think it's incumbent upon the commission to make sure that resource adequacy needs are met in this state. So all three of those are interdependent.
Are they the same, or is economic feasibility different from the perspective of a utility than it is from a utilities customer, perhaps?
It can be. There's a perverse incentive for utilities to function as glorified construction companies, for lack of a better term, to build as much as they can. The benefit in building out a resource that has a very small level of accredited capacity means that we'll just have to build more. We'll have to build more with something else. And because of that, there's a feedback loop of being able to earn more of a profit off of what you're building. And if I'm approaching, the analogy I would give is, somebody working out. In resources that you're putting in there, you might want to focus on, your entire body to be healthy. But if you're only bringing on, resources that are very small in capacity, that's the equivalent of maybe just doing ankle exercises, for example. It's at the expense of everything else and the time that's available or a lot for that. So yes, I mean, from a shareholder standpoint, the ability where Ameren's at right now, you can see that there's a need to build out more generation. How you build that out, whether that's from firm load capacity or intermittent generation that's not reliable, will go a long way in determining what their profit margin is.
Well, let's get more specific. For the Boomtown project, is the economic feasibility from the utility's perspective the same as from its customer's perspective?
No.
Why not?
And again, from the utility's perspective, it is a generation resource that provides some amount of energy into the system, but very little accredited capacity to meet resource needs. So the utility will benefit, non-participants will benefit from this insofar as if there was nothing else, it's better than nothing, but it's not necessarily the best option in meeting both accreditation and capacity and energy.
And you testified that you found the design of the Renewable Solutions Program problematic. You recall that?
I do.
When did you first see the Renewable Solutions Program?
My initial reading of the testimony misunderstood the amount of participants that were involved in the renewable program that's being offered up. It was only after reading staff's rebuttal testimony that I became conscious of the fact that this was a very small overall percentage of customers that would be effectively footing part of the bill.
Did you see the program before Ameren, Missouri filed its application?
I did not.
Did you provide any input to the design of that program?
I did not.
Let me put it this way. Did you provide any input to the design of that program before Ameren, Missouri presented it in this case?
No.
Thank you.
All right, thank you. Thank you for your testimony.
Thank you.
And Mr. Williams, that's your only witness?
That is correct.
Okay.
Yes.
All right, let's go ahead and break until 11:05. So let's go off the record.
Judge, if I may, as a preliminary matter, Dr. Mark gave a testimony in camera. I believe the bulk of that is actually did not need to be done in camera, so I'd ask that with at least the exception of the specific number for the current estimate of the cost of the project, that the remainder be made public to the extent the commission can do so.
And I can see, Mr. Lowry, that you've got your finger over your microphone button.
Yes, I'm sorry to speak over you. I don't really have any objection. I think probably the only thing that's confidential is that number. But I guess the only way to do this is to see. I guess I'd ask Mr. Williams maybe to renew his objection after the in-camera transcript as it's been transcribed is produced, and then I think we can probably agree to declassify some of it, but without reading back, I just, my memory is not completely clear that that was the only thing that was confidential.
Judge, I'm not objecting, I'm just making a motion, but certainly to the extent that the company designates anything else that it views to be, should not be made public. I mean, we can have some discussions in that eventuality, but to the extent that it can be made public, I'm asking that it be made public.
Well, I don't know if this is possible, but would it help to distribute that portion to the parties, that portion of the transcript to the parties prior to making it public on EFIS?
That absolutely, that would solve my problem completely, Judge.
All right, I'll see about doing that.
And I'm fine with that as well. So.
Okay.
Your Honor, I have another preliminary matter. The staff intends, I don't know that there's any disagreement heard with Ameren. There's no disagreement that we will take Jane Doherty's testimony first as staff's witness. So I just wanted to give the commission the heads up on that if there's any, and ask you if there's any issue with that.
No, and I think you brought that up. I think it was you that brought that up first thing yesterday. So yeah,
I think I left it as to when we were going to do it, though, and I wanted to flag you. We're going to start with her, if that's okay.
All right. Then let's go ahead and start with her. So
Staff will call as its first witness Jane Doherty.
all right, good morning, Ms. Doherty.
Good morning.
Would you raise your right hand, please? You swear or affirm that the testimony given in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning. Ms. Doherty, will you state your full name and spell it? Spell your last name for the record.
Sure. My name is Jane C. Doherty. That's Dhority.
And by whom are you employed and in what capacity?
I am a senior regulatory auditor for the Missouri Public Service Commission.
Are you the same Jane Doherty who prepared or caused to be prepared portions of staff's exhibit number 101, which I understand to be your rebuttal testimony in this case?
Yes.
Do you have any changes or corrections to that testimony?
No, I do not.
Is that testimony that's set out in that exhibit true and correct to the best of your knowledge and belief?
It is.
If I were to ask you those same questions, the questions that were posed to you in that exhibit, would your answers be substantially the same today?
They would.
Your Honor, I'm going to offer exhibit number 1 into the evidence, and I'm going to tender this witness for cross-examination.
Mr. Graham, I believe you're referring to Exhibit 101.
What did I say? I meant exhibit 101.
Hey, it happens to us all. Is there any objection to the admission of Exhibit 101? Hearing none, 101 is admitted.
And I've tendered the witness.
All right, Mr. Williams, do you have any cross-examination for the witness?
Not at this time, thank you.
Do any of the other parties have cross-examination?
The company does, Your Honor.
All right. And I see no indication that any of the other parties do. So go ahead, Ms. Grubbs.
Thank you. Ms. Doherty, if the commission approves the CCN and the Renewables Solution Program, staff is not opposed to the company implementing the revenue tracking mechanism that was proposed by the company, correct?
Correct.
Okay. And if the commission would approve the CCN, finding need for the project, but finds that the 50-50 risk sharing for the program is unnecessary, your recommended reporting requirements then wouldn't be necessary, right?
Can you repeat the question?
Yes, ma'am. If the commission approves the CCN, but finds that the 50-50 risk sharing unnecessary for the program, your recommended reporting requirements then would not be necessary.
That's not correct.
Well, there would then be no 50-50 risk sharing.
The risk sharing is not addressed in my testimony. I'll refer you to other staff witnesses on that.
But the reporting requirements would be tracking then the 50-50 risk sharing, wouldn't it?
No, it's not tracking the risk sharing, it's tracking the expenses, revenues, and investment.
Excuse me. Ms. Doherty, could I have you just...
Sit closer.
Yeah, I believe your microphone is on. Just... Yep. Thank you.
But if then there was no 50-50 risk sharing presented, then tracking the expenses, revenues, and investments would be more of an academic exercise, would it not?
Objection simply repeats the previous questions that have been answered.
I believe that I asked if it would then be more of an academic exercise.
Withdraw the objection.
All right. You can answer the question.
No, it would not. Staff would like to track these items in order to assess the success of subscriber and non-subscriber programs.
No further questions. Thank you.
All right. Do any of the commissioners have any questions for this witness?
No questions, Judge. Thank you.
All right. I don't have any questions myself, so Ms. Doherty, thank you for your testimony. Well, you know what? I need to give Mr. Graham the opportunity to redirect.
I wondered about that, but I don't have any redirect. Thank
See?
you.
It all evens out. All right, Mr. Graham, call your next witness. Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Graham.
Mr. Lange, am I stating your last name correctly?
Yes, sir.
Will you please state your full name then and spell the last name for the record?
It is Sean E. Lange, Lange.
By whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission staff as a senior professional engineer.
And are you the Sean Lange who prepared what is, I believe, exhibit number 104, rebuttal testimony?
Yes.
Did you prepare any other testimony? That's the only testimony. Exhibit 104 is your testimony, is that right?
That is correct.
And Mr. Lange, do you have changes or corrections to that testimony?
I have one change, and
And is that something that you prepared a document for?
yes.
Go ahead and explain to the commission what the change is, and then we'll proceed from there.
On page 7, footnote 9, I refer to a MISO document. That document and that link, the link in particular, is no longer in service, if you will. They purge the data every 3 years. And so I have a new link that has the same information as the previous link had.
And so would you like to substitute the correct link or the new link for the old link in your testimony?
I would.
And is that a very, very long URL address?
It is long.
May I approach the witness?
Yes.
Your Honor, I know it's not the record because I'm up here, but I think my staff's next exhibit is going to be 111.
Yes. Yes, I show 111 is the next staff exhibit. Staff exhibit number.
If you want to go ahead and mark that down, I'll go back to my seat and ask questions and get back to it.
And Mr. Graham, do you have copies for us up here?
I have handed you what's been marked for identification purposes as staff's exhibit 111, I believe. Is that correct?
Yes.
And can you describe what that is without reading it all out?
It is basically what I have just described.
Does it state the old URL number that is no longer in service?
Yes, sir.
Does it state the proposed amendment with the URL number that's going to go into, what is the number, footnote 6?
But footnote 9.
I beg your pardon, footnote 9, and that document contains the new URL number?
Yes, sir.
And are you proposing to, are you asking leave to amend your testimony to reflect this change from one URL number to another in footnote 9 or testimony, which is, I believe, exhibit number, whatever I said it was earlier, exhibit number 104?
Yes, sir.
Okay. And is that the only correction to your testimony that you need to make?
Yes.
Okay. With these changes, is your testimony true and correct to the best of your knowledge and belief?
Yes.
If I were to ask you all the questions that are contained within your testimony today, would your answers be substantially the same?
Yes.
At this time, I'm going to offer exhibit number 104 and exhibit 111, and I'm going to tender the witness for cross-examination.
All right, are there any objections to exhibit 104 and 111? All right, hearing none, 104 and 111 are admitted into evidence. All right, Mr. Williams,
No, thank you, Judge.
Mr. Opitz. All right. Mr. Thompson, do you have any cross?
No questions, Your Honor.
Ms. Greenwald? All right. Ms. Pleshia? And Mr. Lowry?
I do, Your Honor. Thank you. Good morning, Mr. Lange.
Good morning.
Schedule SEL-2 to your rebuttal testimony is MISO's November 2022 Regional Resource Assessments Report, correct?
Yes.
You point to it in part for the proposition that once renewable penetrations reach 30 to 40% of the energy being produced in MISO, that planning and operating the grid would become significantly more complex and challenging, right?
Correct.
And you bold a paraphrase of one aspect of the report indicating that to get to a renewable penetration level of 50%, MISO indicates that there needs to be close coordination. Is that right?
Yes, sir.
And on the basis of the RRA report and your observations about it, you give an opinion that staff has some concerns about whether Ameren, Missouri is closely coordinating enough. Is that right?
Yes, sir.
Do you have a copy of your testimony with you,
Yes, sir.
including SEL-2?
I believe I have all of it.
Okay, you do?
I believe so.
Okay, well, we'll find out, I guess. Could you turn to, please, page 22 of SEL-2 and specifically focus on figure 14?
Page 22, figure 14.
Yes. Let me know when you're there.
Okay. I am there.
What does this report project the combined percentage of energy production in MISO to be from wind and solar in 2026?
2026. I believe it shows 28%.
So even MISO projects that it's not going to get to the bottom end of that 30 to 60 or 30 to 40% inflection point by the end of 2026, right?
I believe that could be inferred.
And MISO projects that penetration will not reach that 50% number you mentioned until close to 2036. Isn't that right?
Using that same figure on that same page, that would be what that would show.
In 2036, MISO is projecting 51%, right?
Correct.
May I approach, Your Honor?
Yes.
Mr. Lange, you read Mr. Michael's direct testimony in this case, did you not?
Yes, sir.
And you have some familiarity with his schedules, would that be fair?
Yes, sir.
Would you agree that he included as one of his schedules the company's 2022 change in preferred resource plan, that new preferred resource plan filed last June?
Yes, sir.
And I've handed you a copy of the schedule, which is Schedule MM-D2 to Mr. Michael's direct testimony, which reflects that 2022 preferred resource plan, have I not?
That is what you have provided, yes.
Can you turn to page 2, figure 2 of the document, Schedule MM-D2?
Okay, I'm there.
Figure 2 on page 2 of Schedule MM-D2 shows the expected mix by fuel, or in the case of renewables, I guess by the source of the energy, wind, water, solar, that produce electricity under the preferred resource plan as of 3 future dates. Is that correct? Is that what it shows?
That is what that shows.
Those dates are 2030, 2040, and 2050, right?
That is what that shows, yes.
So by 2030, the preferred resource plan calls for renewables to make up less than a fourth of Ameren, Missouri's generation mix. Is that right?
It's hard to decipher exactly how much. It's a pie chart without, percentages. It is exactly how much.
Excuse me. Mr. Lange, I'm going to ask you to move your microphone a little closer.
I'm sorry, sir.
Thank you.
Would you agree that it's approximately 25% or less, just looking at the size of the various pies in the pie chart? Pie slices, I should say, in the pie chart?
Approximately.
How does that compare to MISO's projection across its footprint in 2031 from your schedule SEL-2, figure 14 that we were just talking about?
SEL2, figure 14 shows wind at 22% and solar at 17%.
Which is 39%, right?
Correct.
As compared to that approximately 25% in 2030 under Ameren, Missouri's preferred resource plan, right?
I believe that's how the math would work out, yes.
Would you agree then that Ameren, Missouri is not projecting to shift toward renewables as fast as MISO itself is expecting to shift toward renewables throughout its footprint?
Citing those sources, yes.
Well, you're not questioning the validity of the sources in some respect, are you? That is MISO's projection that you include as a schedule, right?
Correct.
And the company did file that just last June as its own projection, is that right?
Correct.
How about 2040? Would you agree that under Ameren, Missouri's preferred resource plan, the renewables as its generation mix would still comprise less than 50% as of 2040, assuming it follows its preferred resource plan?
Assuming it files its preferred resource plan, yes.
How does that compare to MISO's projection for renewables in 2041, just a year later?
Total renewables, if we're only looking for wind and solar, it is 55%. If we include a hybrid, then that goes to 60%.
Judge, I need to get an exhibit marked, please. I believe it's number 16.
Excuse me.
Mr. Lange, I've handed you what's been marked for identification as Exhibit 16. Could you please identify it?
What it states on the first page is the 2022-2023 Planning and Resource Auction results.
I mean, this is the slide deck containing, I apologize, I'm backwards. We'll do this one first and we'll come back to the other. I'm sorry about that. This is the slide deck that you cited in footnote 8 of your rebuttal testimony, is it not?
The one that I have just
No.
edited, or the one prior?
The one you just edited was footnote 9, was it not?
Yes.
This slide deck, you provided you cited to it and you provided an active link that actually does work in footnote 9 of your rebuttal testimony. And this is what it's linked to, is it not?
I believe so.
And it reflects the results of MISO's 2022-2023 Planning Reserve Auction, correct?
Yes.
You refer in your testimony to what's called the planning reserve auction as the MISO capacity auction, correct?
Yes.
Would it be fair to say that the takeaway from Exhibit 16, which is this planning reserve auction results from MISO, is that MISO North was short capacity and that this led to the capacity auction price clearing at cone, cost of new entry?
Yes.
You didn't include this in your rebuttal testimony directly, although you linked to it, but slide 5 of Exhibit 16 indicates that MISO North was short despite it importing 3,225 megawatts. Isn't that right?
Yes.
And on slide 9, MISO essentially says that unless more generation is added, shortfalls like this will continue, do they not?
On slide 9?
Yes. The heading at the top, doesn't it? Isn't that what it in substance says?
Yes.
Am I correct that slide 13 of Exhibit 16, as it's been marked in this case, provides granularity about the extent of the shortfall? That is, the capacity needed to meet projected loads and the planning reserve margin requirement was 135.326 terawatts, but the auction cleared with only 134.08 terawatts being offered?
Yes.
But it was just MISO short, excuse me, but it was only MISO North that was short, so the total shortfall I just pointed to was actually greater in MISO North, isn't that right?
Yes.
Could you turn to slide 20, please? Are you there?
Yes, sir.
As of last April, when this report was issued, solar wind penetration in MISO was only 5%, isn't that right?
Yes.
Your Honor, with that, I would offer Exhibit 16, or excuse me, yes, 16, I believe it is, into the record.
Staff has no objection.
All right. Any other parties object? All right, hearing none, Exhibit 16 is admitted into evidence.
I need to get another exhibit marked, please, Your Honor. 17, I believe.
Thank you.
I don't have one.
Shoot.
Mr. Lange, the court reporter's handed you what's been marked for identification as Exhibit 17. Can you please identify it?
This is the 2022 OMS MISO survey results.
And this was cited to you in footnote 5 of your rebuttal testimony, and you provided an active link to it as well. Is that right?
Yes, sir.
You reproduced slide 10 from Exhibit 17 on page 5 of your rebuttal testimony, did you not?
mean, the slide 5 and what I provided on page 5 are slightly different. It is not an exact.
Well, this is the document that you linked to in your testimony, is it not?
Yes, sir.
Are they materially different?
Mr. Lowry, where in his testimony is that located?
Exhibit 17 is the documented to and linked to in footnote of his rebuttal.
Do you have a page number for that?
I will sure get you one.
Footnote 5, I am pulling the map.
I
I'm
may
not
have a
pulling
misreference.
the information that is on slide 5.
All right. Now I'm even more confused. Slide 5 or slide 10?
I may have confused myself, Judge. If you bear with me just a second, I'll try to clear it up. Let me just ask a question. Maybe you can help us clear it up, Mr. Lange. You did cite to the document that's been marked as Exhibit 17 in your testimony, did you not?
Yes, sir.
And you did link to it in your testimony, did you not?
Yes, sir.
Can you tell us where you linked to it?
So on page 4, footnote 5, I say a map showing the different zones are shown below. And then I go into below is the results of the MISO OMS survey for the.
Okay, I think you've straightened me out, Judge. I hope he straightened you out as well. Then is the graph or chart, whatever you want to call it, on page 5 of your rebuttal testimony, that's the same chart that's on slide 10 of Exhibit 17, right?
Yes, sir.
Okay.
I'm
And
sorry
then the
for-
map on page 4 of your rebuttal testimony is the same map as is on slides 3 of Exhibit 17, right?
Yes, sir.
In Exhibit 17, MISO provides additional information and context that pertains to a portion of the slide deck you produced, doesn't it, such as slide 2?
Yes, sir.
Slide 4 explains what the terms shown on the charts mean, does it not?
Yes, sir.
Your Honor, with that, I would offer to admit Exhibit 17 into evidence.
Is there any objection to the admission of Exhibit 17?
If I may just examine this a minute more,
Sure.
Your Honor. No objection.
Those are all my questions, Your Honor.
And I hear no other objections, so I will admit Exhibit 17. Do any of the, excuse me, do any of the commissioners have any questions for this witness? All right, hearing none, I do have some questions for you, Mr. Lange. Based on staff's assessment, when will Ameren, Missouri need additional capacity to meet its customers' needs?
So, based on the information provided, in this case, 2027, it does show that there is a winter capacity need.
And is that something that's in your rebuttal testimony?
I believe it is in, Matt Michael's testimony.
Give me a second, please.
So, Mr. Michael's, rebuttal testimony, page 29, figure 9.
Okay. If the commission were to deny the CCN request, when would you expect, or what would you expect Ameren, Missouri to do to make up the shortfall in capacity?
Well, I believe that they have identified other solutions to help with shortfall capacity, the shortfall of capacity in wintertime. I believe I have outlined that in my rebuttal testimony, and I believe Chairman Roop, I believe you mentioned it yesterday. They are evaluating options to allow certain CTs at Pinot Creek and at Audrain to have the capability of running on fuel oil.
But they are currently in the process of evaluating that, so that's not a certainty, correct?
That is true. What is your understanding of ballpark figure? How long does it take to construct a solar facility start to finish? Probably around 4 or 5 years on average, I would guess.
If there were testimony in the record that it takes more in the neighborhood of 5 to 8 years, would you take issue with that?
Not necessarily. I mean, there could be things that pop up that that could influence that.
Okay. Regardless of whether it's 3 to 4, 5 to 8, whatever it might be, wouldn't you agree that a utility such as Ameren, Missouri can't wait until they are within a year or two of needing that capacity to start on such a solar project?
I would agree that it takes time for planning, for zoning, for getting all the appropriate permissions to construct any kind of facility.
But it's staff's position, is it not, that the need is not there right now?
Staff's position is they have not demonstrated the need.
Okay. In your opinion, is the project as it stands, as it's currently been presented to the commission, is it economically feasible?
I don't think I can answer the economics of the project. I think that would be a better question for Mr. Lubert or Mr. Solomon.
There was testimony yesterday from Ameren, Missouri's witness, Lindsay Berg, where she was discussing the use of investment tax credits versus production tax credits, And there were some schedules where she's showing some modeling of those. And she spoke to work papers and such that support those models. Have you seen those work papers?
I have seen those work papers, but I am not well-versed in those work papers.
Okay. All right, that's all the questions I have. Is there any recross?
I believe I have one question.
All right, go ahead, Mr. Williams.
Judge Sire asked you about how long it takes to build a solar plant from start to finish, and you responded 4 to 5 years. How are you identifying start and finish for purposes of answering that question?
That is generally what I would see. So as far as
what are you identifying as a starting point for coming up with your estimation of 4 to 5 years?
for my estimation, the starting point would be on average kind of when we are aware of the project. So either that is, I'm sorry.
I'm not looking for a time period. I'm looking for what point in time that you're identifying as being the starting point for coming up with your estimation and the finishing point.
So the finishing point would be kind of an average in-service date, commercially operational, something along those lines. As far as the start date, I was looking at kind of trying to recall other projects that I have worked on as far as when staff has became aware of those projects versus the end point of, having them commercially operational.
All right. Could I interrupt, Mr. Williams? So really, it's more of what you consider the start of the project. Do you consider that when a utility like Ameren, Missouri, makes a decision that they'd like to look into the possibility of building a solar project, or is it more when construction starts or something in between?
Well, as far as other projects that I'm aware of or that I have at least partially worked on, it depends. There have been projects where we have gotten information about the RFP when it was let, kind of what was, what was being sought, and that type of information. Other projects, we have not gotten information until, the utility company comes in and lets us know either through meetings or through other filings or that.
Okay. Go ahead, Mr. Williams.
RFP, you mean request for proposals?
Yes, sir.
And because a utility issues request for proposals does not necessarily mean that it's actually going to go forward with a project, does it?
That is correct. It does not.
No further questions. Thank you.
All right. Is there any other recross?
We have recross, Your Honor.
All right. Mr. Lowry, go ahead.
Mr. Lange, on that same subject, what is the capacity of solar projects that you have worked on as a member of the commission staff? What's the biggest one?
I'm trying to recall. I don't think I can answered that question sitting right here.
And just to clarify, I was asking about nameplate capacity. Did you understand that when I asked the question?
That was my understanding from,
You would agree that no other Missouri IOU regulated by the commission has a solar facility that's anywhere close to the size of the Boomtown facility, wouldn't you?
I believe that is correct.
Wouldn't you agree that any facility you've actually worked on that the utilities brought to the commission for approval, for example, is significantly smaller than the Boomtown facility in your personal experience?
I can't recall every case, but I would say that some of the projects that I have worked on have been substantially smaller.
I mean, how big is Ameren, Missouri's O'Fallon Energy Center, do you know?
I'm sorry, I have a lot of numbers running in my head. I don't think I can answer that right now.
Do you have any personal experience with identifying, locating, et cetera, solar projects to potentially be built?
I'm sorry, could you repeat the question?
Have you personally been involved in an effort to go out and find and evaluate solar projects that a utility might build?
Have I performed the evaluation?
You can answer that question. And I'm talking about the evaluation from the utility's perspective, not an evaluation after the utility might bring it to the commission as to whether you agree with the utility's evaluation.
I have not made that evaluation from the utility side of things, no.
You don't have any personal experience in all the steps necessary from issuing the RFP to evaluating the RFP results to identifying a project to negotiating the contracts, et cetera. You've never done that yourself, have you?
From the utility's perspective, I have not done that.
Well, I mean, you haven't done it as a staff member either, have you?
I have provided staff position on certain aspects of the company's plan or perhaps RFP or along those lines. But as far as myself putting out an RFP, I have not done that.
You've never negotiated an agreement with a developer to build any renewable facility, have you?
Your Honor, I'm going to, now, I've let this go, but I'm going to interpose an objection here that this far exceeds the scope of the questions that were asked from the bench.
Well, I think the bench asked how long it takes to build or construct or develop a renewable project, and all of the questions I'm asking go to that timeline.
Right, but I think you've made your point.
Okay, fair
So,
enough.
I'll sustain that objection.
You indicated that you have reviewed the work papers that the judge asked you about, correct? But you weren't, I don't want to put words in your mouth, but you can disagree if I mischaracterize it. You weren't a master of them, or you weren't intimately familiar with their operation. Was that a fair characterization?
Yes.
The company, I think on more than one occasion, did make itself available, I think Ms. Forsberg in specifically, and perhaps Mr. Wills or others, to meet with and walk through and answer questions about those work papers. Is that fair?
I believe so.
Well, I think you participated in those discussions, did you not?
I just don't know how many there may have been that have not, that I was not a part of.
Did you participate in at least 2 such discussions?
I believe so.
Okay, thank you. Those are all the questions I have, Judge.
All right, thank you. Mr. Graham, do you have redirect?
Off. Now I'm on. Thank you, Your Honor. Yes, I have some questions. First of all, would Boone on its own fulfill the winter capacity need that's been identified?
No.
Mr. Lowry directed you to page 9 of the PPA. Can you read the title of that slide? PRA, I beg your pardon.
I'm sorry.
And that's Exhibit 6, excuse me, Exhibit 16, correct?
I believe that's right.
Okay.
I believe we wrote. Yes, that's 16.
Could you repeat the page number or the slide number?
Page 9. And I don't know that I have the slide number.
Judge, it's actually 17, I just, so the record's clear.
Looks like it's
Leave.
9. Page
All right.
9.
Well, let's get that straight first, because I thought the reference was to the PRA, which I believe is Exhibit 16.
That's right, I'm referring
You're
to
right,
page
I
6.
apologize, Your Honor, I had them backwards and had to be straight.
And
Slide
Mr.
number.
Graham, I believe if we want to call,
It's slide 9, I understand.
slide and page are the same numbers.
Yeah, but we probably better decide which one we're going to call them for the record. And I think everybody's been using the expression slide, so do you understand the question?
That's
with
fine.
Slide, Mr. Lange?
Sorry, slide 9?
Well, I'm going to start the question again. Mr. Lowry directed you to either page 9 or slide 9, however you wish to understand it, of the PRA. Can you read the title of the slide?
Slide 9, the title states, unless more capacity is built that can supply reliable generation, shortfalls such as those highlighted in this year's auction will continue.
And can you define reliable generation in your view?
Reliable generation, that can mean, and at least in my mind, goes to dispatchability, less variables that are, wind and solar are dependent upon when the wind blows and when the sun is shining. Dispatchability tends to be more reliable in that a unit, if given a signal, more often than not, can generate up to the level that is dispatched to.
Excuse me, Mr. Graham. Can I ask you this? Do you believe that's what MISO understands the term reliable generation to mean?
Your Honor, I think you mean to direct the question to Mr. Lange and not Mr. Graham.
Oh, I'm sorry. Did I say Mr. Graham? Mr. Lange. So that's your understanding. That's what you would understand reliable generation to mean. But do you believe that's what MISO intended it to mean for the sake of this document?
I would say that I think in August, when MISO has been here before the commission talking about these very same issues, that they have taken a position that at some point, some time, there will need to be additional dispatchable resources that is installed in the grid.
And by dispatchable, you mean when we need that generation, when we need that energy, it can be brought online.
Yes, that's how I would mean that in that context, yes.
Which would be the case if it were nighttime in the case of solar, or the wind not blowing in the case of windmills.
Correct.
Okay. Go ahead, Mr. Graham. I'm sorry to hijack your questioning.
Thank you, Your Honor. Had you completed your discussion, your understanding of the term reliable generation? I think the judge interposed a question. I wasn't sure whether you were done with your answer.
I believe I am done.
Okay, thank you. Judge asked the question about need, and you stated that staff's position is that the company has not demonstrated need. Can you elaborate on that and state what, in your mind, speaking as the staff's witness, is missing from Ameren's case that causes you to conclude that it has not sustained its burden?
Sure. Yesterday, every Ameren witness demonstrated, well, at least talked about this energy need. What I have gathered from the work papers and information from Matt Michaels and Ameren witnesses and work papers and information that has been provided in this case, I would refer to that more as a net purchaser situation, that we currently have utilities in the state that are in a net purchasing situation. That in and of itself does not mean that the grid is going to collapse because it's in a net energy situation and they are a net purchaser. It just means that, you know, and what they have provided is an annual net purchase amount. So a lot of this is dependent upon, you know, the hours in which there is need, what the load is doing in those hours, what the assumed losses are for the load, what the assumed growth is for the load, what all of that information is doing in those hours, as well as what assumptions for fuel, what assumptions for fuel price, what assumptions for plant outages, what all that is doing at the same time. And so the company has not provided information to show where the shortfall is on an hourly basis or over the year. They show there is a net purchase situation at the end of the year. I don't know how I can equate a net purchase situation to an energy need.
All right. Do you recall Mr. Lowry's questions challenging whether or not you had ever worked on a project, a solar-powered project of the magnitude of Boomtown? You remember those line of questions?
Yes, sir.
Do you remember his line of questions referencing you by way of comparison to much, as he may have described it, much smaller projects?
Yes, sir.
Okay. Did you, in fact, work on the Huck Finn case?
Yes, sir.
Is that a comparable case to the Boomtown case that we have before us today? In magnitude, in size, in complexity?
Largely, yes.
Okay. I believe that concludes my questions.
All right. Just, Mr. Lange, one short question. If I were to tell you that in that Huck Finn solar project that the application was requesting 200 megawatt, would you agree with that, or
Yes, sir.
does that sound familiar?
That does sound familiar, sir.
And that is compared with the 150 megawatts
In this current
case?
Yes,
Okay.
sir.
All right, thank you. All right, and the commission appreciates your testimony, and you may step down.
Thank you.
All right, it is about 12:07. Let's break for lunch until 1:15. Is that acceptable? Okay, let's go off the record. All right, we are back on the record. Mr. Graham, call your next witness.
Yes, Dr. Susan Wong.
Good afternoon. Would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Graham, you may proceed.
Dr. Wong, would you state your full name and please spell your last name for the record?
My name is Jun Won, last name W-O-N.
Thank you. Dr. Wong, who employs you and in what capacity?
I work for Missouri Public Service Commission as the manager of Financial Analysis Department.
And are you the same Dr. Wong who prepared or caused to be prepared portions of staff's exhibit number 107?
Yes.
I believe that's rebuttal testimony, is that right?
Yes.
Do you have any changes or corrections to your testimony?
No, I don't.
So is your testimony true and correct to the best of your knowledge and belief?
Yes.
If I were to ask you the same questions that were posed to you in that earlier testimony, would your answers be substantially the same?
Yes.
I'm going to offer into evidence exhibit number 107 and witness for cross-examination.
Is there any objection to the admission of Exhibit 107? All right, hearing none, 107 is admitted.
And if it wasn't clear, I've tendered Dr. Wong for cross-examination.
All right. Mr. Williams, do you have cross-examination for the witness?
No, thank you.
All right. Do any of the other parties have cross-examination?
The company does not.
All right. Do any of the commissioners have questions for this witness? Dr. Wong, I do have questions. So, Mr. Lowry, your instincts were correct. Did you have the opportunity to hear testimony from yesterday?
Not all.
Okay. Did you hear any of Ameren, Missouri witness Lindsay Forsberg's testimony?
Some of that.
Are you familiar with, just a second here, the schedules that were made a part of her rebuttal testimony? There is a model, there's a project scenario modeling.
I know, but I'm not detailed investigation about that.
Okay. If I were to show you that, or have you pull up that schedule, would you be in a position to answer questions about it?
I may not.
Okay. I'm going to go ahead and ask the question anyway. She models different scenarios and introduces a discount rate. Do you have any familiarity with that?
Yes, I know what is the discount rate.
And in her modeling assumptions, she has that listed under revenue requirement parameters. So what is that discount rate? Not the number, but
So discount rate is used for the net present value of the project. So that is related to economic feasibility, the compare to the project. So my expertise is financial ability. That means Ameren Midri can fund to the project or not. It's a little different topic.
okay. So you wouldn't feel comfortable testifying as to whether you thought their discount rate was reasonable or not?
That is depends on the market situation and depends on the project purpose. So I didn't investigate that topic in this proceeding.
Okay. And that modeling had to do with whether investment tax credits would be part of this project or whether production tax credits would be part of the project. And Ms. Forsberg testified yesterday that there were work papers that supported her numbers. Did you have occasion to review those work papers?
No.
Okay. When it comes to the project, the solar farm, would it be a part of Ameren's rate base for its useful life of 30 years?
So would you rephrase your question?
The estimated life cycle of the solar farm is 30 years, its useful life. Would you assume that that solar farm would be made a part of the rate base for those entire 30 years?
So that topic also, I'm not an expert for that.
Okay.
Sorry about that.
No, it's all right. I'm wrong, but did your testimony touch on those two tax credit programs?
So what I did is I introduced what they planned, and then they canceled their original plan, and then what they have a plan. But my decision is not based on their regarding the tax credit related matter is not my main cause of this decision. To Ameren Midri has a financial ability to the project.
Okay. But in your testimony, you stated, did you not, that you support the production tax credit versus the investment tax credit?
So that is I described what they report to us. Then, as we know, the detail of the project plan is not set up yet. And then that is a subject to if they have some real plan, they need to come back to another request for the commission.
So are you saying at a particular point in time, when it appeared that Ameren, Missouri would use the production tax credits, are you saying at that time that you supported that?
If they provide enough information, then we can review, and then we can decide that is a proper or not.
Do you have any opinion over or any opinion about the benefits of one tax program over the other? No.
No.
Okay. The investment tax credit program typically involves a tax equity partner. Does staff have an opinion on whether that is more advantageous to ratepayers versus use of the production
Not
tax
right
credit?
now.
I'm sorry,
Not right now. I
Not
have
right-
no.
not right now.
Yeah.
Okay. All right, that's all the questions I have. Is there any recross? Any redirect, Mr. Graham?
No, Your Honor.
All right. Thank you, Dr. Wong.
Thank you.
Mr. Graham, call your next witness. All right. Good afternoon, Mr. Fortson. Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and the truth?
I do.
All right, thank you. Mr. Graham, you can go ahead.
Thank you, Your Honor. Mr. Fortson, would you state your full name, please, and spell your last name for the record?
Brad J. Fortson, Fortson.
Mr. Fortson, who employs you and in what capacity?
I'm employed by the Missouri Public Service Commission as a regulatory compliance manager.
And Mr. Fortson, are you the same Mr. Fortson who prepared or caused to be prepared staff's exhibit number 102?
I am.
Do you have any changes or corrections to your testimony?
I do not.
Is your testimony true and correct to the best of your knowledge and belief?
It is.
If I were to ask you the same questions that are posed to you in that testimony, would your answers today be substantially the same?
They would.
At this time, Your Honor, I'm going to offer into evidence exhibit number 102.
All right, is there any objection to the admission of 102? All right, hearing none. Exhibit 102 is admitted into evidence.
Staff tenders the witness for cross-examination.
Mr. Williams, do you have any questions for the witness?
Not at this time, thank you.
All right. Mr. Opitz?
Thank you, Your Honor.
Mr. Thompson?
No questions, Your Honor.
Ms. Greenwald? Ms. Pleshia? All right. Mr. Lowry?
Just a couple, Your Honor, I think. Good afternoon, Mr. Fortson.
Good afternoon.
In the past few preferred resource plans for Ameren, Missouri, prior to the change in preferred resource plan filed last June, Ameren, Missouri's preferred resource plan didn't really call for any major generation additions during the implementation period, right?
That's correct.
And the reason it didn't call for, if it did call for any major generation additions, it called for them beyond the 3-year implementation period. In fact, well beyond, generally speaking, isn't that right?
Depending on what you consider well beyond, but beyond the implementation period, yes.
Well, like the combined cycle plants that were out in the 2030s and any of those other IRPs, isn't that right?
Yes.
Would you agree that's well beyond the implementation period?
Sure.
And in your experience with Ameren preferred resource plans, again, prior to the June 22 filing, was that as part of the annual update process, staff and maybe other stakeholders would have meetings with Ameren, and Ameren would essentially express, as part of those annual updates, that it was business as usual, nothing major had changed. Is that right?
That was, yeah, that's typically generally how those meetings went.
You would agree that under the Commission's rules, the implementation period is 3 years after the triennial IRP is filed?
I believe that's how it's defined.
You agree that the Commission's IRP rules call for a preferred resource plan, and as part of that, or as at least part of the rules, there's also supposed to be an implementation plan. Is that right?
Yes.
The application in this case was filed last July, and that was within the 3-year implementation period for the 2020 triennial IRP, correct?
Within the implementation period, yes.
Okay. Thank you, Mr. Fortson.
Are there any questions from the commissioners for this witness? Go ahead, Chairman.
Thank you, Judge. Good afternoon.
Good afternoon.
I think yesterday somebody brought up Ameren's Missouri Solar Partnership Program. Did the commission put a hold harmless provision or a 50-50 sharing mechanism in that case?
I apologize. I don't know.
Okay. Can you remember any CCAs in the last 10 years where the commission has done something similar to that?
So in the last 10 years, I haven't participated in many really CCN cases until recently. Okay. So Mr. Lubert might be able to answer that better.
All right. Cool. Thanks.
All right. Any other questions from the commissioners?
No questions, Judge. Thank you, Holzman.
All right. Mr. Fortson, I do have a few questions. How are the sale of solar renewable energy credits currently treated?
So if Ameren was to sell the renewable energy credits?
Right.
So if I recall right, I could be getting out of my wheelhouse a little bit, but the sales of renewable energy credits, the revenues from the sales of RECs will typically flow through the FAC.
And in this case, if the CCN and the RSP is approved, will the treatment of the sale of those solar RECs continue in the same fashion?
I believe so. I didn't focus, or my testimony wasn't focused much at all on the program, but that is my understanding.
Okay. Based on staff's assessment, when will Ameren, Missouri need additional capacity to meet its needs?
I believe I would agree with Mr. Lange's testimony that, as in Mr. Michael's testimony, there would be a shortfall of winter capacity in 2027.
2027, okay. And you've been in here and heard other witnesses' testimony. I've got the same question or questions for you about Ms. Forsberg's testimony and her modeling of one tax credit program versus the other tax credit program. Did you review that modeling?
For purposes of my testimony, I did not. I apologize. You have to keep asking these questions, but no, I don't have a specific answer to those questions.
So you didn't. You said for the purpose of your testimony, but have you have you seen those schedules, and have you seen the work papers?
I can't say for certain.
Okay.
Through my review, there's a likelihood that I would have seen them. To recall them offhand right now, I
Right.
can't.
You weren't tasked with reviewing
Correct.
and judging the reasonableness or anything like that?
Correct.
Okay. All right, is there any recross?
I guess a couple questions, Your Honor.
All right, go ahead, Mr. Lowry.
Mr. Fortson, you indicated that you think that when solar RECs are sold, that the revenues from those would flow through the company's fuel adjustment clause, right?
Yes, I believe that's how that would work.
But how sure are you of that?
So it's been a little while since I've dealt directly with the RECs and Ameren, Missouri in particular. So I may be confusing utilities and functionality of that.
If you know, first of all, the only RECs, and if you know, the only REC Ameren, Missouri has produced thus far from any renewable generation facilities through any mechanism have been for res compliance, isn't that right?
I believe that's correct.
And the RECs that would be generated by this facility would not be generated for res compliance, right?
That's my understanding.
So and I'm just really trying to clear up the record. I'm not really trying to prove you were right or wrong about anything, but I just want to make sure the commission has the accurate information. You don't recall, for example, that REC revenues for RECs retired for renewable energy standard compliance actually flow through the RESRAM? Does that sound right?
That does sound right.
You're aware, are you not, that Ameren, Missouri has proposed a tracker in this case that is designed to make sure all of the revenues from the program will be, because there's not a rider mechanism authorized by statute, but will be deferred on its books, and then they can be included in revenue requirement in each rate review, right?
I'm not greatly familiar with it. Sounds accurate.
And if the commission adopted that tracker, allowed Ameren, Missouri to defer them, and then presumably the commission would certainly allow and offset a reduction to revenue requirement in base rates, then all those revenues, if the program was approved, would come back to customers. Isn't that right?
Can you say that one more time? I apologize.
Let's say the facility generates, 100,000 RECs. This is just an illustration at $5 a REC in between rate cases. So that'd be $500,000 of revenue, right?
Sure.
If there's a tracker that says, Ameren, Missouri, you track and defer that $500,000, when Ameren, Missouri comes in for a rate review, Ameren, Missouri would reduce its revenue requirement by either $500,000 if it was a one-year amortization period, or maybe it was 5 years, so it'd be $100,000. But in either case, that $500,000 fixed rates would come back to customers, right?
So I don't think I would argue that it comes back to customers, but it's a benefit that's not offsetting costs. So I guess I wouldn't call it a benefit, but revenues are flowing back to customers based off what you just said, if I understood it right.
I mean, if it was the FAC or the RESRAM, the revenues would flow back more in real time. It would be quicker because you've got this ongoing periodic adjustment through a rider, right?
Sure, but there's still a cost of the project or the program in base rates.
There's still the cost of renewable energy standard resources and base rates too, right?
Sure.
But the REC revenue comes back through a rider, right?
It does.
And here, in the case of the company's tracker proposal, the REC revenue is going to come back. It's just going to come back in a different manner. Isn't that fair?
I believe it is fair, but there's probably others that can answer that.
You've answered my question. That's all I have, Judge.
Mr. Lowry, can I ask you this just for the sake of clarity on the record? You referred to RESRAM, RESRAM. Can you tell us what that stands for?
Renewable Energy Standard Rate Adjustment Mechanism.
All right, thank you. No, I did not. But I will ask you now, do you have redirect for the witness?
Thank you, Your Honor. Just a couple almost procedural type questions. Would staff witnesses Koenigan and Stallman be able to address specifics about the RSP?
Yeah, that's why I sort of caveated that I might have been getting out of my wheelhouse a little bit.
Okay. And those specific to RECs could be addressed to Mr. Koenigan?
Yes.
And questions regarding Ms. Forsberg's work papers could be addressed to witnesses Stallman or Lubert?
Yes.
That's all the questions staff has.
All right. Thank you for your testimony, Mr. Fortson.
Thank you.
And Mr. Graham, you can call your next witness.
Mr. Stallman.
Mr. Stallman, you have your right hand raised. Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Thank you.
And proceed, Your Honor.
You may.
Mr. Stallman, would you please state your full name and last name for the record?
Michael L. Stallman, S-T-A-H-L-M-A-N.
And Mr. Stallman, who employs you and in what capacity?
The Missouri Public Service Commission as a regulatory economist.
And are you the same Michael Stallman who prepared or caused to be prepared staff's exhibit number 106, which is rebuttal testimony?
Yes, and I also have some rebuttal testimony.
And is your surrebuttal 109?
Yes.
Thank you for your help on that. Do you have any changes or corrections to the testimony in either of those exhibits?
With what is noted in my rebuttal testimony, no.
And I believe that, well, would you explain what you mean by that change or correction or whatever to the surrebuttal, which is exhibit number 109?
In my rebuttal on page 1, starting at line 17, I make a correction to my rebuttal testimony to correct some of the highly confidential numbers.
Okay. And have you written that into some document?
Yes,
Those changes?
that's in my rebuttal testimony.
That has been filed with the commission?
Yes, exhibit 109, I think.
So that the corrections that you've made, you have already made in the document that has been filed in EFIS as your exhibit number one, what that is exhibit number 109?
Correct.
Okay. I think the nature of my questions is that beyond those kinds of corrections that have been filed in EFIS, do you have, as you sit here today, any other updates?
No.
Okay. So changes to exhibit number one, with the changes that apparently are now present in exhibit 109, is your testimony true and correct to the best of your knowledge?
Yes.
And if I were to ask you the same questions that were posed to you in those two exhibits, would your answers today be substantially the same?
Yes.
At this time, Your Honor, I would tender into evidence staff's exhibits 106 and 109 as explained by the witness.
Is there any objection to the admission of 106 and 109? All right, exhibits 106 and 109 are admitted into evidence.
Thank you, Your Honor. At this time, staff tenders the witness for cross-examination.
All right. Mr. Williams, do you have questions?
Not at this time, thank you.
All right. Do any of the other parties have questions on cross-examination for this witness?
Not at this time.
All right. Do the commissioners have any questions? Okay,
No questions, Judge. Thank you.
all right. All right, Mr. Stallman, I do have some questions. Can I refer you to your rebuttal testimony, page 8?
I am there.
All right. And without citing any of the numbers, because it is a highly confidential document, there is quite a change in the annual revenue requirement in the year 2035. What has occurred there? What is the significance of that change in the annual revenue requirement?
And I think recalling from the work paper, that was when the production tax credits expired, or it was either that or when the RSP program ceased to put dollars into the into this revenue requirement.
Okay. And how far into the project would the RSP not be?
It was anticipated to be 15 years out of the 30
Okay, and this
projected.
this figure 4 starts in 2020.
2035, so yeah, I would anticipate this is dealing with the expiration of the production tax credits.
Okay. Now I'd like to direct you to your rebuttal testimony. On the second page, at the bottom of that page, let's see, you state the economics of the Boomtown project are dependent on the type of tax credit utilized, actual energy production, and associated revenues. Given that Ameren, Missouri has not selected which tax credit they will use, how could that impact the projected cost and economics?
So when we're looking at the revenue requirement of the project, the reason why we're just addressing the revenue requirement for this case was mainly because the Ameren and their direct testimony made a claim that this would be essentially projected to be revenue neutral throughout those 15 years, that the subscribers would be largely paying for this project. And it was our understanding at the time that the RSP program was driving a lot of the need for this project in particular, and it seems that they've changed that too in their rebuttal positions. But so here, when we're looking again just at the revenue requirement parts of it, the increase of costs and of the projected project and the potential switching to different tax credits is going to have a large change. Ms. Forsberg's rebuttal assumed that another company would essentially provide them that loan, and that's not actually what the current case is. That is projecting that from a case they have not filed yet. In this case, we don't have with us right now an ITC modeled for what they're currently projecting. Did look at the production tax credit, and as filed in the original case, we put in 2 changes to that original filing, which was to increase the cost to the HC number of the now projected cost, and we also added an adder to the production tax credit based on their testimony. And when we ran those numbers, we found that the cases are much worse now than what they were when they had direct filed, so that there was no scenario that did not have a net present value revenue requirement that was less than zero.
When you mentioned another company, would that be a tax equity?
That's that tax equity partner.
Okay.
The name escaped me.
Okay. So at various times during this hearing, I feel like I've been playing a little bit of a whack-a-mole, trying to find the correct witness to ask about Ms. Forsberg's modeling. Can you speak to that?
I can.
Okay. So did you have access to or review her modeling that was used to develop the scenarios that she presented in her schedules to her direct testimony, as well as her supplemental direct testimony and rebuttal?
I reviewed a lot of the, I can't say that I specifically challenged each and every number, but I did review a good portion of her work, yes.
Okay. And did you actually see her work papers?
Yes.
And reviewed those closely?
Yes.
Okay. And you had discussions with Ameren about those work papers?
I don't know that I've actually discussed with Ameren those work papers. I know I've had internal discussions with other staff members.
Did those work papers essentially speak for themselves?
Yes.
Okay. Did you know those work papers and that modeling to be reliable?
We took their assumptions that, yes, the assumptions that were modeled in those we took to be reliable, yes, with the exception with the rebuttal includes the tax equity partner, and that is not something that is currently subject to this case. We did not address the presence of a tax equity partner at all.
And is that because at the time that those work papers were given to you by Ameren, the assumption was that they were going to use the production tax credits?
Correct. And the rebuttal, the direct, or the revised direct, they came and said they were not going to use that tax equity partner. And so we took that as face value, that they would not use that. And then when they filed rebuttal, they threw in the potential for the tax equity partner.
When I refer to Ms. Forsberg's Schedule S1 or LJF-S1, do you know what I'm referring to?
I think you're referring to her, is that one of her graphs? Or are you referring to the work paper?
It is one of her, I will call it one of her tables as opposed to a graph.
I don't have that in front of me, but I'll look to my counsel to provide that.
Yeah, that would be my preference. Sure. And again, this is a highly confidential document, and so I don't want you to refer to specific figures, but I do have some questions about that schedule and, well, mostly about that Schedule S1. Yes, if you don't mind. Yes, Mr. Graham, thank you.
Thank you. This.
For clarification, Judge, what document you're exactly, which table or schedule you're asking about?
What I am referring to, I believe it's part of her rebuttal testimony, but I can double check on that. Lindsay Forsberg's Sir rebuttal testimony schedule LJF-S1. And at the top of that document, it says Boomtown Solar Project Modeling Assumptions. I've got a copy.
I think I have it now.
Okay, well, go ahead and take a minute to look at that Schedule S1. And you've seen this schedule before, correct?
Yes, I've glanced at it in testimony, but I mainly reviewed this in her actual work papers.
Right. And so, like I said, the heading of that document says Boomtown Solar Project Modeling Assumptions. And so it essentially is laying out the assumptions, the parameters that led her to her revenues, RSP benefit figures, and so forth. So, but my questions are about the assumptions themselves. Do you, and again, they're in many different categories: basic project parameters, revenue requirement parameters, energy generation, et cetera. Do you find those, the actual numbers, do you find them to be reliable?
I would say we did not challenge these specific numbers, so we did rely on these numbers when I was developing rebuttal.
Well, that's a little different than the question that I asked, because you said you relied on them, but did you find those reliable? Did you find those reasonable?
I think that with my general understanding, they're fairly reasonable, yes.
Okay. All right. Those are all the questions I have. Is there any recross?
I think just a couple questions or a few questions, Your Honor.
Okay, go ahead, Mr.
Ballman, I may have misheard you, so if I did, just tell me that I did, but I thought you said something along the lines in response to one of the judge's questions that we didn't have the ITC model, or we didn't have ITC model results. Did I mishear you?
For the Sir rebuttal, I do not know that we have the ITC modeled without a tax equity partner.
Okay, you were saying you don't know that you have the ITC model results if we would assume we don't need to use a tax equity partner.
Correct.
Okay, but you do have, and you were just discussing them with the judge, you do have the modeling results, assuming that ITC is used and the normalization rules essentially necessitate the company uses a tax equity partner. You do have those results, right?
With a tax equity partner, yes, we do.
Okay. And then I thought you decided that in no case, and I think you were referring to Ms. Forsberg's results based upon the modeling parameters that the judge just asked you about in LJFS1. I thought you said that in no case with the ITC would the project or program lower revenue requirement, was projected to lower revenue requirement. Did you say that?
We looked at with the production tax credit in that scenario, is what I was referring to, not the ITC.
Are you saying that you misspoke?
I think I said production tax credit. So we reviewed the tax credit because we do not have the tax credit without the tax equity partner.
Mm-hmm.
We reviewed the production tax credit that was given to us in the original case, and we put an adder on that.
Okay.
And then
So-
with the production tax credit.
So these schedules, and it's LJF S-1 and S2, those do not envision to the investment tax credit or tax equity partner.
S1 and S2 assume an ITC, investment tax credit, and a tax equity partner.
So the opposite of what I just said.
Correct.
Okay.
So Judge, if you give me just a second. I didn't anticipate we were going to talk about Ms. Forsberg's testimony with Mr. Stallman, so I need to find something here.
So, Mr. Stallman, just so I don't know that I'll be perfectly clear about this, but hopefully I'll understand it. So S1 and S2, strictly an evaluation based on the assumption that production tax credits would be used.
That's incorrect. My understanding is with the assumptions listed here in the S1, it talks about tax equity financing. And so it has the, in that second table part of it has an ITC listed. What staff did was we went back to the original model in the supplemental direct and looked at the production tax credit and reran a model with that production tax credit in mind because for two reasons. One, we do not have an ITC without the tax equity model. I'm not familiar with how that would be modeled appropriately, and that was not something given to us. And it was also because the tax equity partner is assumed for the purposes of this case to not be an issue. In supplemental direct, they said they were not going to go with the tax equity partner. Does that make it clear?
It helps.
Okay.
May I inquire, Your Honor?
Go ahead, Mr. Lowry.
So just to clear up the record a little bit, I think. And now I've got the wrong one. No, this is supplemental. Oh, yes, you do. My apologies. So, Mr. Stallman, did you testify in answers to the questions from the judge, that is before I started asking you questions again, did you testify that Ms. Forsberg's surrebuttal, which models use of the ITC with a tax equity partner, that in none of those cases did the results indicate a reduction in net present value of revenue requirement?
I did not testify to that.
Did not. You recognize that in one of the cases without the program, it does show reduction in net present value revenue requirement. Do you recall that?
I think that is accurate with assumptions that are not in this current case.
And in two of the cases, if you layer the program on, it shows a reduction in net present value revenue requirement, right?
I would have to relook the work papers, but I think that is correct.
Well, the record will show whether it is or not. But you do recall that not all the cases showed an increase in net present value revenue requirement in Ms. Forsberg's surrebuttal, right?
For assuming tax equity partner assumption, yes.
Assuming there's an ITC
And
with a tax equity partner, right?
Yes.
And if the company doesn't need to use an ITC, would you expect that to lower the cost of essentially using the ITC? In other words, those results would get a little bit better if you want to call better, lower in revenue requirement, right?
Are you saying without the tax equity partner?
Well, let me try it this way. Using tax equity has a cost associated with it, right? Would you agree with that?
I think so. I would actually reserve that more to Jay Lubert.
Okay. Is your answer you don't know?
I'll say I don't know.
Those are all the questions.
All right. Mr. Graham, do you have redirect?
Yes, Your Honor. Okay, in the discussion with the judge, you were just asked about the economics of the Boomtown project. You mentioned staff's analysis of the NPVRR of the project, assuming PTCs and based upon cost increases. May I approach the witness?
Yes, you may.
This is going to be 112.
Thank you.
Paul, is that what this has been marked, 112?
All right. Just for the sake of the record, Mr. Graham is circulating a potential exhibit 112, and that's what I wanted to mention. It's highly confidential. It does have numbers that are protected by the highly confidential rules. So go ahead, Mr. Graham.
And have I actually, did you the 112? I gave it to so many people, I'm not sure if I left one in your hands.
Yes, you did.
Now, you've heard the cautionary about its being highly confidential. Can you identify what this exhibit is?
This was an exhibit I prepared based off of Ms. Forsberg's supplemental direct testimony. And this was based on the production tax credits, not the investment tax credits, production tax credit. And it has the updated cost of the project. And it also added an adjustment to the production tax credit in some of those scenarios where it says with PTC adder. And that was based on staff's understanding of their SIR rebuttal testimony with regard to the Inflation Reduction Act.
So that's what that exhibit is. Have you also, with your answer, basically outlined what this exhibit shows? Or do you want to, I'm going to ask you that question. What does the exhibit show?
Your Honor, I'm going to interpose an objection and perhaps ask to void ire the witness. The information that I believe this was based on was provided to staff on January the 9th, including the work papers that demonstrated the change, the expected change from going from PTC to use the ITC with the energy boost, et cetera. And it's true that we didn't put it in testimony until SIR rebuttal because SIR rebuttal wasn't due until whatever day it was due a couple of weeks later. But we specifically communicated with staff and provided this information, and now staff's coming in here on redirect when we don't have a chance to respond and wanting to put a document based on analysis in the record with different net present value revenue requirement figures that it could have provided in its SIR rebuttal. We don't have any work papers. We don't have any. I have no way to cross-examine this witness about these results whatsoever. They've essentially sandbagged and to get it in at a point in time when we don't have any ability to respond. And it deals with the PTC anyway, and we've testified, as you heard yesterday, that it certainly appears we will use the ITC, and if we use the PTC, or if we have to come back, we will come back. So I don't think this is proper. I don't think it's proper for the staff to be allowed to do this.
I definitely see your point. But I also believe that that the commissioners and myself will take that into consideration, that you have not had that opportunity to respond. So I'll overrule your objection. And Mr. Graham, you may continue.
I appreciate that, Judge. I hope if we perhaps, and I don't know whether or not, seek leave to respond in some fashion, a record post the hearing, that motion will be entertained.
Okay.
The question that I had, you've just summarized, or you've stated what the exhibit is. Can you tell us what this exhibit shows?
This exhibit shows that based on the information staff had based on the understanding of what Ameren, Missouri's case is, that there was no tax equity partner. We ran through scenarios based on the production tax credit, which is information, the only way we have to model a tax credit, which was given to us at Supplemental Direct. And it goes through the various scenarios that Ms. Forsberg did in her Supplemental Direct. So this is comparing an apple-to-apples basis with the updated project cost with a higher production tax credit adder through various scenarios, and it shows that under no scenario does the revenue requirement go below zero.
Is that what he just said? Okay. And you just got to my next question. So, did staff have an opportunity to respond to the surrebuttal testimony position of Ms. Forsberg?
Objection. That calls for a legal conclusion as to whether the staff had an opportunity or not.
I do not understand why that calls for a legal conclusion.
Well, staff had the work papers and the information on the 9th of January. The question is whether they could have addressed it in their surrebuttal testimony or not.
That's entirely a factual argument. I didn't hear any part of it that was a legal argument.
I think it's a question of whether the commission's rules and rulings would allow that to happen or not.
I'll overrule the objection. Do you need him to repeat the question?
Restate the question. Did staff have the opportunity to respond to the surrebuttal testimony position of Ms. Forsberg?
No, and I don't recall getting specific work papers with thing on January 9th offhand.
The assumptions in the LFJ-S1 do not consider the hourly generation of the asset and hourly loads. Is that correct?
Correct.
You were asked some questions about ITC and tax equity. Is it possible that staff may have additional concerns that were not addressed in this case if a tax equity partnership is introduced?
Yes, Mr. J. Lubert would have some, I know he has identified concerns prior to the withdrawal of the tax equity partner as they did in Supplemental Direct.
Your Honor, at this time, staff would offer what's been, I believe I marked, identified, and testified concerning as Exhibit 112. We would offer it into evidence, subject, of course, to all of the confidentiality protections.
Judge, I'd just like my objection noted for the record.
So noted. And so, technically, Mr. Graham, this would be 112 HC, correct?
Yes. Yes, it would. Thank you for the correction.
All right. I will overrule that objection and admit Exhibit 112 HC.
I think that's all the questions for this witness. That's all the questions staff has for this witness.
Okay. All right, Mr. Stallman, thank you for your testimony.
Thank you.
Mr. Graham, who do you anticipate your next witness to be?
Cedric Cunigan.
How, do you have kind of a rough time estimate?
I think we have very little for Mr. Cunigan.
I should probably ask myself that question. Do I have a time estimate?
Judge, it's a really good thing to have, so.
Yeah, Judge, you may have an inside track. But I think the parties here, he wants to know fair.
What I'm really getting at is whether it's necessary to take a break right now.
15. Anybody want to break?
I'd like to take a break before we get done with all the witnesses, but right now, I'm okay personally.
All right. All right.
Shall we go on?
Yes, let's go on.
All right, Cedric, you want to come on up?
All right. You've got your right hand raised. Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Graham, you may proceed.
Mr. Cunigan, would you state your full name and spell your last name for the record?
Cedric Cunnigan, Cunign.
And Mr. Cunigan, who employs you and in what capacity?
The Missouri Public Service Commission, and I'm a senior professional engineer.
And are you the same Cedric Cunigan that prepared or caused to be prepared portions of staff's exhibit number 108?
I don't have exhibit numbers, but I did file rebuttal and surrebuttal testimony.
All right. Well, if I represent to you that your testimony is 108, can we use that name?
Yes.
Okay. Do you have any changes or corrections to your testimony?
No.
So is your testimony true and correct to the best of your knowledge and belief?
Yes.
And if I ask you all of the same questions that were posed in that pre-file testimony, would your answers today be substantially the same?
Yes.
Your Honor, I will offer into evidence staff's exhibit number 108.
Is there any objection?
Judge, understanding there are two exhibits, 100 and 108, and that 108 is a surrebuttal testimony.
Yeah,
Public counsel does not have an objection to the surrebuttal testimony, nor, if it's offered, the rebuttal.
Well, thank you very much. And with that, Your Honor, I probably better go back and regroup. Mr. Cunningham, all of my questions were referenced to exhibit number 108. If I ask you all of the same questions now that I asked you of exhibit 108 concerning your rebuttal testimony, which is exhibit 100, would your answers be the same?
Yes.
Your Honor, at this time, I tender into evidence exhibit 100 and exhibit 108.
All right. So the question now is there any objections to the admission of exhibit 100 and 108? All right. Hearing none, 100 and 108 are admitted.
Thank you, Your Honor. Staff tenders the witness for cross-examination.
All right. Mr. Williams, do you have any questions on cross-examination?
Thank you, no, at this time.
Do any of the non-Ameren parties have questions on cross-examination? I'm seeing a lot of shaking heads, so I'll take that as a no. Mr. Lowry, any cross-examination?
Actually.
I'm sorry, Ms. Grubbs.
Just briefly, please.
Mhm.
Mr. Cunningham, you recall in your rebuttal testimony providing a recommendation that if the commission were to approve the Boomtown CCN, that a condition for as-built drawings for the project be provided. And I believe you had the time frame as no later than 60 days after commercial operation. Is that correct? Page 4?
Yes.
Okay, thank you. So have you reviewed the verbal testimony of Ajay Aurora, company witness, that has been marked as hearing exhibit 2?
I reviewed it. I don't have it in front of me right now.
Renewable. Were you present or aware of an exhibit number 14 being entered yesterday that was a slight revision to that term, or the response to that recommended term?
You're going to have to refresh my memory on what
May
that
I-
was.
Sorry, may I approach, Your Honor?
Yes, you may.
Thank you.
Do you have a copy of that for me to look at before you get?
It's one, or number 14, but I do have another copy.
Oh, is that the 14 that's come in this morning?
No, came in yesterday.
Here you go. Just an extra.
Thank you, thank you. Thank you very much.
Sure. And Mr. Cunningham, have you reviewed then what's been marked as Exhibit 14?
Yes.
And so within this, there's a proposal to shift basically from that 60-day time frame to 100 days after final completion. Is that accurate?
Yes.
Do you have any concerns with that revision as proposed by Mr. Aurora?
Me personally, I do not.
Thank you very much for your time.
All right, do the commissioners have any questions? Okay, it appears that there are no questions from the commissioners. All right, I do have a few questions. Are you familiar with Dr. Mark's testimony?
Yes.
Okay. In his rebuttal testimony on page 19, the Office of Public Counsel suggested, and I'll quote here, "At a minimum, the Renewable Solutions Program should be modeled around a 50-50 sharing mechanism that accounts for undersubscribed accounts." What is staff's opinion about the 50-50 sharing mechanism?
We've used the 50-50 sharing mechanism in the past for, let me get the writer out. The Community Solar Program. So we used it for that program for Ameren, and we've used a similar mechanism for other utilities in Missouri. But this was on the basis of the program being purely voluntary. And all of those programs were pilots at the time, a much smaller size.
Much smaller in terms of megawatts?
Yes, I think 5 to 10 megawatts, maybe even smaller for
Versus
the first
150 in this case?
Correct.
Okay. Do you know how many annual RECs the Boomtown Solar Project will have?
Taking this from, can I say numbers that were in Forsberg's work papers, just referring to megawatts?
Just for megawatts, I'm sorry, just to clarify.
Yes, just megawatts generated.
That's not confidential.
Okay.
That's good, thank you.
So they estimate the beginning of the project around 338,000 RECs, and then it drops off as degradation over time. That would be the 0.5%.
So that degradation also affects the RECs?
Yes, our RECs are directly tied to megawatts generated.
Okay. Do you know what the current market value of RECs are in Missouri? The cost or the value per megawatt? I'm sorry, the value per REC.
That is a very hard question to come by. There is not a lot of data outside of the renewable energy standard reports. I can tell you what Ameren paid in 2021, but that doesn't speak to voluntary REC prices, and those are slightly different.
Would you agree that the value of those RECs will change over the life of that renewable generation asset?
Yes, the value of RECs have fluctuated a lot, just based off of demand, supply, but then also certain regulatory requirements, and it varies by state. Some states don't have renewable portfolio standards. RECs would be cheaper there, I would assume, than states that have higher renewable portfolio standards. And I'm not entirely familiar with where Illinois is at.
Okay. And I'm not sure how much of the other testimony you've heard so far, but if the commission were to, and I've asked this question of other witnesses, but if the commission were to approve only the CCN for the project without the RSP, the subscription side of it, would the RECs be owned by Ameren?
Yes.
And could they monetize those RECs?
Yes, we haven't seen Ameren do that in the past because they've purchased RECs mainly, but we have Empire has sold RECs previously. We do see that.
Could you envision Ameren selling them every year?
If they had excess, yes.
Okay. What is your opinion, particularly as to whether this project is economically feasible, given that the project costs have increased since the application was first filed, but also given the potential change in the use of tax credits from when the application was first filed?
So I don't testify to economic feasibility, and I focus mainly on the program. But my stance on that my stance on the program wouldn't necessarily change due to the tax credits.
I see. And would you say the same thing about the project costs?
I don't testify on project costs, specifically on the program or the tariff.
Okay. All right, that is all the questions I have. Yes, Commissioner. Sorry, Chairman.
Oh, no, you're
Chairman
fine.
Root.
Thank you, Judge. He mentioned something that I was trying to get at earlier. So you mentioned the community solar program pilot that Ameren had, that we did the 50-50 on. Is that the same as Ameren's Missouri Solar Partnership Program from 2016? Is that the same thing, or are they different?
So Ameren has the Community Solar Pilot Program, which is on sheet number 158 of their tariff. And then they have the Community Solar Program, which is no longer a pilot, on sheet 89 of their tariff. And then there was a separate program. I have to excuse all my shuffling. Okay, here we go. And then the Renewable Choice Program. And that's on sheet 94. So I'm not sure the time or the date of the program you were referencing, but these were the three similar programs I was able to find in their tariff.
Okay. Yeah, it was EA-2016-0245 was the case number, but I'm sure it's one of those. I'm probably.
If I was guessing, I'd say it would be the Renewable Choice Program.
Okay. had a solar partnership program.
If I may,
Yes.
I believe take judicial notice of that docket number, that there was a partnership program.
That was before I started working there.
Hey, I understand that. So of those three you mentioned and the one we're taking notice of, the number that had any type of a 50/50 or hold harmless provision, is it just the community solar program you mentioned for Ameren? Or did the others have anything similar?
I believe it was just the community solar program and the pilot.
Okay. And then you also you mentioned that there were other utilities that had something similar. And I was looking at the KCP&L GMO Solar CCN from 2015. Do you remember, probably before you were here, does that have a 50/50 or hold harmless? Or how about the ones you said other utilities, which ones were you referencing?
Evergy and Liberty both, well, Liberty has a case pending, but both have a sharing mechanism pending in Liberty right now.
Okay. Then the judge was talking to you about Ameren's possibility of monetizing their RECs. Is there value in not monetizing those and keeping them, even allowing them to expire so that they can say that their customers, percentage of their customers' energy comes from renewable sources?
I don't know that I would say there's value in allowing to expire, but there is value in the RECs. Whether they sell them, I mean, they can hold them for 3 years if they are needed. More RECs for their own compliance, things like that.
So is Ameren, in this case, making any argument that was similar to the Evergy case where OPC had filed a case against Evergy because they allowed so many of their RECs to expire? Is Ameren making any type of an argument that along those lines similar to that case?
I don't believe so in this case.
Okay. Do you believe that I guess you already kind of said that you didn't believe that there was value in allowing them to expire. Okay. Thank you, Judge. That's all I had. Thank you.
All right. Okay, and correct me if I'm wrong, Mr. Graham, you haven't had the opportunity yet to redirect, have you?
Are we going to have an opportunity to recross?
I see.
Okay, sorry.
My gut feeling was that I missed somebody along the line. So yes, besides Ameren, Missouri, do any of the other parties want the opportunity to recross this witness?
I have a couple of clarification questions.
Mr. Williams for public counsel, go ahead.
Mr. Cunningham, do you recall talking about RECs, and I believe you used the word megawatts generated? Is that correct?
Yes.
What is your understanding of megawatts?
Megawatts is capacity. It would be megawatt hours. 1 megawatt hours is what it takes to create a REC.
Thank you for that clarification. I believe you did not answer Judge, your question about staff's opinion about public counsel's 50/50 sharing proposal. Does staff have an opinion about that proposal?
Staff's recommendation in this case was to have the full cost of the program be on the subscribers during the program phase. And that was made under the, I don't know the right word, assumption or standing that the project wasn't needed. And so sharing it, if it was, it wouldn't have been staff's go-to for this particular case.
Would it be better in staff's opinion than shareholder or customers bearing the full cost?
Yes.
Thank you. No further questions.
All right. Ms. Grubbs, go ahead.
Thank you, Your Honor. Mr. Cunningham, I just wanted to clarify, when you were being questioned by the judge, you described the community solar pilot and we'll call it full program, right? Do you recall that?
Yes.
And the community solar pilot as well as the full program are optional programs, right?
Yes.
And you are familiar with the Montgomery Solar Energy Center that was the second phase of the community solar pilot?
Yes.
And for that facility, the company did apply for and obtain CCN approval before it commenced construction of that facility, correct?
Yes.
And in doing so, it did not suggest that without the program that the Community Solar Energy Center would be built, correct?
Can you say that again?
So it was not proposed that the Community Solar Energy Center would have been built without that community solar program, correct?
To my knowledge, yes.
So the need for that facility was directly linked to the community solar program.
I would say yes, but it's also kind of in the tariff that the community solar program was to provide an opportunity for those customers.
Thank you very much, Your Honor, and thank you for your time, Mr. Cunningham.
All right. Mr. Graham, do you have redirect?
Yes, Your Honor, getting there. Chairman Rupp asked about hiring RECs. Would there be environmental attributes for those if they are retired?
What do you mean by environmental attributes?
If retired as opposed to expiring. Chairman Rupp asked about expiring RECs. Would there be environmental attributes if the RECs were simply retired?
The RECs in general represent the environmental attributes. So whether they are retired or expire, they still represent that generation or the attributes tied to that 1 megawatt hour. The retiring of RECs goes toward compliance, and so someone can lay claim to it. So if they expire, no one lays claim to it.
Is this a different facility? You familiar with Montgomery Solar Facility?
Yes.
Does the size of that facility compare with the Boomtown project?
It's much smaller. I can't remember if it was 5 megawatts or 10. I believe closer to 5. It's not 150.
It's not 150.
Correct.
What was the cost range from Ameren's purchased RECs in 2021, if you know?
You're referring to the purchase price of RECs that Ameren paid in 2021?
Yes.
I It was anywhere from $3 to $6.25 per rec for that compliance year.
Can you comment on how that fact relates to the implied costs per rec in this case?
So the implied cost per rec in this case is lower than that after 2021.
That's all the questions that I have, Your Honor.
All right. Thank you for your testimony, Mr. Cunningham.
Judge, if it pleases the bench, would this be good time for a short break?
Let's make it, actually, let's make it I'm going to suggest a 15-minute break and proceed on the expectation that we will finish the hearing today. Does that seem reasonable? Okay. So, we'll, I guess it's up to me again, huh? So, we will reconvene at 3 o'clock, and we are off the record. All right, we are back on the record. Before we get to Mr. Graham's next witness, Mr. Lowry, when it comes to the Exhibit 15, the work papers that support Ms. Forsberg's, for lack of a better word, I'll call it analysis. I think I suggested that you just email those to our email address for exhibits, but you're perfectly welcome to submit those through EVIS, and we'll take it from there. Yeah, sure. Yeah, yeah.
And I will tell you, Judge, they may be so large that we are going to have to send them to the data center or to you, whichever you
on a
prefer,
CD
on
or
a CD,
what have you.
because they're pretty involved files, as I recall.
Okay. Okay. All right. Mr. Graham, are you ready to call your next witness?
Yes, Jordan Hall.
All right. All right. Mr. Hull, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you're about to give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Graham.
Mr. Hall, would you state your name and spell your last name for the record?
My name is Jordan T. Hull, last name Hull, H-U-L-L.
And Mr. Hall, by whom are you employed and in what capacity?
I work for the Missouri Public Service Commission as an associate engineer in the Energy Resources Department in the Industry Analysis Division.
And are you the same Jordan Hall that prepared staff exhibits number 103 in this case?
Yes.
Do you have any changes or corrections to your testimony?
No.
Is your testimony true and correct to the best of your knowledge and belief?
Yes.
If I asked you all the same questions today that were posed to you in that exhibit in your prior testimony, would your answers be substantially the same?
Yes.
Your Honor, at this time, I'm going to tender into evidence exhibit number 103.
All right. Is there any objection to the admission of 103? All right. Hearing none, Exhibit 103 is admitted.
Staff will tender this witness for cross-examination.
All right. Mr. Williams, do you have questions?
Not at this time, thank you.
All right. Do the other parties besides Ameren have any questions for this witness? Okay. Indication is no. Ms. Grubbs, do you have questions?
I do not. Thank you.
All right. All right. Do any of the commissioners have questions for this witness?
No questions, Judge. Thank you.
All right. All right, Mr. Hull, I just have a few questions. And first, and I've asked this of other witnesses, but given that from the time of application to, I don't know that it's, I'm not sure when the numbers were updated, but the estimated project costs have increased. Given that, would it be your opinion that this project is still economically feasible?
I didn't have anything in my testimony that was outside of the scope of what I was looking at.
Okay, fair enough. And did you yourself have opportunity to review those work papers that supported Ms. Forsberg's analysis? I'm trying to find the schedule number. The schedules LJF-S1 and S2, the project scenario modeling.
I did not. I was assigned to look at if the company was qualified to own, operate, maintain, and otherwise control and manage for this project.
Okay, so you didn't have any discussions with anyone from Ameren about those work papers?
No.
All right, those are the only questions I have. All right, is there any recross? All right, hearing none. Mr. Graham, any redirect?
No, Your Honor.
All right, Mr. Luber. Oops, sorry. Mr. Luber, you have your right hand raised, so do you swear or affirm that the testimony given in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Graham?
Mr. Luber, will you state your name and spell your last name for the record?
Sure. My name is Jay Lubert, spelled just the letter J, and Lubert is spelled Luebbert.
By whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission staff, and I am the manager of the Tariff and Rate Design Department.
And are you the J. Lubert who prepared staff's Exhibit 105 rebuttal testimony in this case?
I am.
And do you have any changes or corrections to that testimony?
I don't believe so.
Is the testimony reflected there true and correct to the best of your knowledge and belief?
I believe it is.
If I were to ask you all the same questions that are posed to you in that pre-file testimony, would your answers be substantially the same?
They would.
Your Honor, I would tender into evidence or move for the admission of Exhibit number 105 into evidence.
All right, is there any objection? All right, hearing none, Exhibit 105 is admitted.
And staff tenders the witness for cross-examination.
All right, Mr. Williams.
No questions, thank you.
Any questions on behalf of the parties that are not Ameren, Missouri? All right. The answer is no. Mr. Lowry?
Just a couple, I think, Your Honor. Mr. Lubert, you were here, I believe, for Mr. Stallman's testimony earlier this afternoon.
I was.
Do you have any reason to believe that Ameren, Missouri would use the production tax credit tax strategy as opposed to the investment tax credit tax strategy? Not a very good question. Do you have any reason to believe that Ameren, Missouri would not choose the tax strategy that is most advantageous to its customers?
I don't know that I would be comfortable stating what Ameren will or will not do in the future, right?
Well, I didn't ask that. Do you have any reason to believe that Ameren would pick a tax strategy, the tax strategy that is less advantageous to its customers versus the one that's more advantageous? Do you have any reason to believe that?
I don't know that I do, but I will say that the introduction of a tax equity partner is something that we did not address in testimony and likely would have if we thought it was on the table.
I understand that, but you don't have any reason to believe that Ameren, Missouri would intentionally choose the PTC if the ITC was better for customers or vice versa, do you?
I don't know that I have any evidence that says that Ameren would do that. No.
And if
Your Honor, I want to object to this line of questioning. It substitutes these speculative questions for what staff did not actually have an opportunity to do here, as the witness is repeatedly trying to say. And the counsel is endeavoring to get this witness to validate those numbers in that testimony without a proper opportunity to do things per the procedures of this commission, which would have given this witness and this staff the opportunity properly to respond to these changes. I'm objecting to this line of questioning.
I don't believe I've asked any questions, asked this witness to validate any numbers. the inference that's been drawn by some of the testimony that staff gave earlier today, when they come in and they remodel with the PTC, et cetera, when the company has testified under oath that it's going to use the tax strategy that's most advantageous and in fact intends in all likelihood to use the ITC, I'm just exploring whether this witness, who I think is staff's main witness in this case, has some evidence that would suggest the company's going to make a decision that's harmful to its customers.
Absolutely the same objection.
And I do agree with Mr. Graham on this point, so I will sustain that objection and add that line of questioning.
Very well. I don't have any other questions.
All right. All right. Are there any questions for this witness from the commissioners?
No questions, Judge.
All right. Thank you. And that was Commissioner Holzman?
That is correct, Judge.
All right. All right, I do have a few questions.
There was never a doubt in my mind.
Let's see. Do you have your testimony, your rebuttal testimony?
I sure do.
Okay. If we go to pages 4 and 5.
Okay, I'm there.
Is it staff's recommendation to reject the renewable subscription program?
We are recommending that the Renewable Solutions Program, well, if you'll give me just a moment, I just want to make sure that I'm not misstating anything.
And I'm sorry, if I called it the Renewable Subscription Program, I meant to say the Renewable Solutions Program, which is a subscription program, but
Okay, so I wanted to clarify because pages 3, 4, and 5 actually include a summary of our recommendations, and we gave a few different options for the commission, right? Our primary recommendation was that the commission reject the application for the CCN as well as the tariff sheets associated with the Renewable Solutions Program. And that, I think that's on page 3, so that may have been where.
so it begins on page 3. And so correct me if I'm wrong, basically it's staff's position that they would not recommend the commission approve the subscription program, the RSP. But if the commission chooses to approve the program, you would recommend these conditions, and there are 9 of them, correct? Or no, I'm sorry. There are 9 conditions. There are 9 conditions that you would attach to the CCN approval. Is that correct? Starting on page 3.
Yeah, so page 3 and into page 4 discusses what staff's recommendation would be if the commission determines approval of the CCN as appropriate. On page 5, there are some additional conditions that we would recommend if the commission approves the project, so approves the CCN, as well as the Renewable Solutions Program.
Okay.
And so the conditions on page 5, numbers 1 through 4, would be conditions in that scenario.
Right. Are there any specific modifications that staff would recommend to the rider language?
If you give me a few moments, I can go through. I realize that I'm kind of the last witness for staff up for the day.
I think we're ahead of schedule, actually.
Okay.
Again, it's really kind of up to me. It's what it kind of feels like.
No, understood. Let me see. I've got some other staff witnesses' testimony, and they would probably address the specific language within their testimony, but I can kind of thumb through and see if I can give you a synopsis, if that would be helpful.
Okay.
Do you have a pen over there? Or a highlighter? Thank you. Can I ask for a clarification really quick? Is your question, if the commission were to approve the RSP, are there recommended changes to the tariff language? Or do we just, okay.
Yes.
And so I think that may alter the question a bit, and so as I'm reading through, I just want to make sure that I've got the question clear.
And I will say, when you asked for a highlighter, I checked the drawer here at the bench and did not see a highlighter, but did see a note that said there are additional supplies in the drawer behind me, and there is a variety of colors of highlighters and a bottle of Tums. So
I don't think I need the Tums yet, but if you could loan me a highlighter, I'd greatly appreciate it. That's okay. One of them, well, I'm sure. Thank you.
And I don't know if anyone else in the hearing room needs one of those Tums, but the expiration date is 1998.
I'll pass on those, thank you.
At least you cautioned before they were handed out, right? Okay. I appreciate the patience. Unfortunately, I don't have Mr. Cunnigan's surrebuttal testimony, which I think may have included some potential conditions. And with that said, our recommendation and rebuttal testimony hinged on the assumptions of the costs that were included at the time of supplemental direct. So our rebuttal testimony doesn't reflect the increased costs that we're now kind of we're reviewing this case within that context, right? As of surrebuttal. But I do think that there are some conditions that we recommended, and generally with a case such as this, at the end of the case, there would be a commission order, and the tariff would need to be updated to reflect those conditions that would be included in that order. And so I think a lot of what we've recommended obviously would be consistent with our written testimony. And if that were so ordered, we could address that at the time of compliance tariff filing. But I think it's actually, I'm sorry. I do have his surrebuttal. I may not have his rebuttal testimony. Okay. So Cedric Cunnigan's surrebuttal testimony includes some recommendations with regards to the Renewable Solutions Program. One of those is that staff is recommending that all of the costs of the renewable generation facilities in the program be borne by the subscribers and/or shareholders while the RSP phase is in effect. Any recalculation of the RRC, and let me get, I believe that's the renewable resource charge, should ensure that the program and facilities costs are fully covered during the program phase. He then goes on to state that if the commission chose to approve the RSP, staff would support adding language to the tariff outlining the retirement of RECs on the customer's behalf, in addition to the following conditions staff proposed in rebuttal. So all costs of the renewable generation facilities in the program shall be borne by subscribers and/or shareholders while the RSP phase is in effect. In addition to an in-service evaluation at the time of the facility is initially placed into rates, Ameren, Missouri shall demonstrate the facility is fully operational at the time the RSP program ends. And then third, the costs of the generation facilities to be placed on ratepayers will be determined at the time the RSP program ends. The valuation of the facility will take into account the current book cost, the state of the facilities, depreciation, degradation over time, and current market prices for similar sized asset. The least cost option will be chosen.
And that was in his surrebuttal testimony on pages 2 and 3, correct?
That was in his surrebuttal, and if you'll give me a moment, I may have had a couple more that that weren't brought up there. So.
Judge, it's obviously up to you, but if Mr. Lubert identifies other staff witness testimony that says X, Y, and Z, it's in evidence, we probably could save some time if he's not reading it all into the record.
Yeah, I agree with that. So let's move on. And these are similar questions that I've asked other witnesses, and I believe you've been here throughout the hearing. But do you believe, will the actual solar farm be part of the rate base for its useful life of 30 years?
I believe that is Ameren's intention with this program, or with this project, is to include the cost of the assets in rate base.
And if Ameren used the same discount rate it has used for other NPV value calculations, what would be the net present value of having that project in rate base for 30 years?
So I can't speak to the specific discount rate that Ameren's assumed in their work papers. What I can speak to some of the analysis that Ms. Forsberg provided, and I guess if that is the kind of the line of questioning that you have, I will say that the analysis that she provided for the net present value of revenue requirement assumes it relies on various assumptions that are not certain at this time. Revenues being one that is, and I think my testimony talks about this, but the revenues from the asset is uncertain and won't be known until sometime later, likely at the end of this asset's life. I do talk about in my testimony that the costs are relatively certain, and I use that term relatively in rebuttal prior to knowing that the costs would be increasing, kind of to the level that they would be in rebuttal, and so obviously that I still think that the costs are relatively certain, and they will be certain by the time that the project is placed into rate base, with the exception of a few ongoing costs. But the vast majority of the costs of this asset will be relatively certain in the near term, while the overall economic outcome will not be for some time.
Would the net present value be different in the first 15 years that the project's in the rate base?
Is that assuming that the Renewable Solutions Program was not approved?
Well, I was going to say, assuming it is approved.
Okay. So, again, you have to make some assumptions, right? And so if you assume that the Renewable Solutions Program is approved as envisioned by the tariff filing at the beginning of this case, I think the expectation, if you're comparing to an option of not having the program, but also not selling the RECs, then the answer is the program would reduce revenue requirement compared to that case. However, I think that staff would argue, and I think certainly OPC has argued in the past, that if there are RECs that are in excess of Missouri res requirements and a utility is allowing them to expire without trying to gain the value that ratepayers have paid for, that it may not be prudent to do that. And so if you're comparing to a scenario in which the utility has the asset but not the Renewable Solutions Program and sells those RECs, the answer is that it depends on what the market value of the RECs that they can sell is. We don't know with certainty what the market value of those RECs will be over the 15 years. But what this program, in my eyes, what this program does provide is for the 10 participants, they have a relatively fixed idea of what those RECs will cost them. But that is not something that I think Ameren has been willing to I don't know that they have been willing to project or guarantee what they expect that price to be. And I'm sorry that my answer doesn't give you a straightforward A versus B, but I think that this is, the program itself lends itself to some complication.
Understand that I am a lawyer, and so I do understand everything is not in black and white. There is that gray area. I want to shift gears a little bit, and I think most witnesses would agree that Ameren is going to face additional capacity needs. When do you think that Ameren will need additional capacity to meet its customers' needs?
So I am going to give you another multi-answer. And the reason behind that is the capacity need that you may have is dependent on the time period. And I think Mr. Lange talks about MISO moving toward a seasonal capacity construct, which is, it differs from years past as far as the MISO planning resource auction, in that it's not just one time a year that you're looking at what the peak is for the footprint or the zone. You're looking at multi seasons. And so I think there's some figures within Mr. Michael's testimony, and if you give me some time, I can point you to the specific ones that I'm looking at. But I think in 2027, they're projecting that their accredited capacity from a MISO standpoint would be less than what their projected peak is in that year for winter. And sometime, I believe it's in 2030, it may be in 2031 after the retirement of Sioux, that they're projecting that same, or they're projecting a capacity deficit in the summer in that time frame. And I think what we've heard from the utilities witnesses yesterday is that the expectation is that due to that retirement of Sioux, that capacity is going to be replaced by the combined cycle, which they plan out in that same time frame.
And for the sake of the court reporter, we have a different court reporter today than yesterday. So Sioux is SIOUX?
Yes.
And that refers to?
The Sioux generating facility.
Okay. Okay.
It is I guess, should I clarify? That is an existing coal plant in Ameren, Missouri's fleet. Is that helpful?
It is to me. I would assume it's helpful to the court reporter as well. Public counsel has suggested the possibility of a 50-50 sharing mechanism. Do you have any opinion on that?
Yeah, so I think the way that I understood Dr. Mark's testimony as I read it in rebuttal is he may not have had a full grasp of what the Renewable Solutions Program was actually doing. And he talked a bit about having a 50-50 sharing mechanism for the unsubscribed portions of the RSP. Now, as it stands, I think the way that the company's witnesses have described it, and possibly some other parties as well, is that it is currently oversubscribed, meaning that they have customers that are willing to take on additional capacity if it becomes available. And I think the current tariff sheets allow, or at least it envisions that Ameren may come back in for an additional CCN, and that would be kind of rolled into the Renewable Solutions Program. While I understand his concern, I think that because of the kind of the current subscription level, the concern that there may have been with some of the other renewable programs, as I understand them, was that, you know, an asset may be built prior to kind of having a full subscription, and then that the remaining amounts may cause some risk. So I guess I would say that I don't think that Dr. Mark's proposed 50-50 sharing goes far enough, and that is reflected by what our recommendation is that if this program is designed to meet a quote-unquote need from these larger industrial customers to be able to show these renewable attributes, right? That if that is the need that you're trying to meet, then the subscribers should bear the costs of the entirety of the project. Now, I think that some of the testimony is written, and this is especially true, I think, in the direct testimony, is that there's this illusion, and I guess illusion with an A, not an I. I think that's an important distinction, but there's an illusion that to this concept that the subscribers are going to be paying the vast majority of the overall costs of the asset. And so part of that tariff is that you have a fixed charge that's based off of the megawatts or the kilowatts of the asset itself. But then you also have a credit to the bill that those participating customers would get on their bill that would offset that charge. And so I think with Mr. One's testimony speaks to this, and I allude to it in my testimony as well. The result is that a vast majority of these costs are not actually borne by the participants. They're borne by ratepayers as a whole, and there's a small offset based on the participants. Now, I have a percentage in my testimony, and again, that's based off of the cost that was provided to us as of supplemental direct. So I think the effect of the increased cost without changing any of the parameters for the Renewable Solutions Program is that the participant contribution is actually decreased on a percentage basis compared to the overall cost of the project. And so I think an important aspect of this case is understanding that if a project is being kind of pursued because of a small handful of participant wants or needs, then the risk that the project is ultimately uneconomic should be borne by those same entities, right? And if not those entities, then shareholders as opposed to ratepayers as a whole.
Somewhat in the same vein, with the increased estimated project cost, do you still feel that the project is economically feasible?
So I will say that the increased cost along with some of staff's concerns about the economic efficiency of the decision to go forward with Boomtown, I think the concern is heightened from a staff's perspective. The feasibility of the project, I think, I think Mr. Stallman's testimony talks about this, but from the utilities perspective, it is, as long as they have they have a reasonable expectation that they'll be able to recover the costs through their rates, I think the utility would assume that it is feasible for them to put the money up front as long as they could get recovery later, right? Now, I don't know that staff came out and said that this project is not economically feasible. We raised concerns with the economic efficiency of moving forward with it, and that's probably falls more under the public interest. My testimony talks a lot about why avoiding adding assets that may not be necessary at this point, or adding them well in advance of a need, can place some additional risk on ratepayers. And so that's part of this. Did I answer your question?
Yes.
I'm sorry.
Yes, but how would you respond to Ameren's position that if they wait until the need is absolute, that then it may be too late as far as a solar project goes because of the years that it takes from conception to bringing it online?
Yeah, no, I'm glad you asked about that. So some of the testimony from other parties in this case appears to paint the picture that staff has this position that we should be waiting, and I shouldn't have said we, that Ameren should be waiting until a point that a deficit's already occurred and then building an asset to make up for that deficit. And that is not our position. What our position is that in a case where a utility is asking for a certificate, they have the burden of proof of demonstrating what the need is and why, or what the need is, so that we and the commission can evaluate what the alternatives might be for fulfilling that need. So obviously we talked in our rebuttal testimony a lot about how inefficient it is to build a solar asset for a winter capacity need. And all of that is absolutely true. But that is why it's important to identify what the need is, so that we can kind of make that comparison of what the alternative or the, I'm sorry, I'm drawing a blank. What the alternative economics may look like. And there was the last part of your question, and I feel like I have not answered that. If you could ask.
It's pretty late in the day, so I don't know that I can come up with that question. But it was essentially keeping in mind that it takes years to build a solar project.
Yes, I'm sorry, and that's where I wanted to get to, and I apologize for not getting there faster. So I think it's an important, some important context to keep here, that in the last few, I don't want to say anything that's confidential, but I don't think that I'm going to get there. In the last few CCN cases that Ameren has had for renewables, they have done so through a contract structure. Can I talk about just generally?
Yeah, the contract structure is not confidential. The fact of the contract structure, no.
Just the details within it, right?
The commercial terms,
Sure,
pricing,
okay.
those kinds of things, yes.
Okay. So Ameren has gone through several CCNs in recent history in the last few years, and staff's been a signatory for several of them for renewable assets. And the way that, at least the ones that I'm most familiar with in recent history, the way that Ameren has gone about that is through what's called a BTA, or a build transfer agreement. And essentially what that process looks like is Ameren might issue a request for proposals, get responses back from developers, and those responses may be in various stages of development. And so there may be some projects that, haven't gotten a single permit done, haven't done any field work, and there may be some others that are much more farther along or advanced. And so kind of the concept that it might take, if you turn down this project, that it may take 8 years before you see another solar project in from Ameren isn't really, I wouldn't say it's a very good assumption, because of the fact that in the MISO interconnection queue, there are thousands and thousands of megawatts of not only solar, but there are also some wind projects that they've requested study from MISO to interconnect at a specific point. And so kind of the timeline that you're looking at, it really depends on how far along in the development of a specific project may be. And through this request for proposals, Ameren has the ability to say, we would like a closing date or a operational date by year X. And presumably that is the responses that they would get from that request. And I don't think that it's not like the request for the RFPs that I'm familiar with have not been, there's only 3 responses. There have been a multitude of responses, and obviously you narrow from there based off of what your preferences are.
Okay, there is one last area I'd like to get into, and I believe Mr. Graham indicated earlier that you may be able to speak to staff's review of Ms. Forsberg's modeling and the work papers involved with that. So did you have access to the work papers that supported Ms. Forsberg's, I believe it's Schedule LJF D3, SD2, and S2? So connected with supplemental direct and rebuttal testimony.
So I did have access to those papers, and I did review them. I don't know that I have, I know that I have the supplemental, I think it was S1 and 2. I have those printed off for certain. I may or may not have the direct. And so if you've got specific questions, I think I can pull it up on EFIS if needed.
Really, they're more general questions.
Okay.
So you did have a chance to review those work papers in detail?
I did.
And did you have discussions with people at Ameren about the work papers and the modeling?
I did.
Okay. Did you find the modeling in the work papers to be reliable?
So I want to break my answer into 2 separate answers, and the reason being is that in the initial direct filing, there was an assumption of a tax equity partnership. In surrebuttal, the analysis that Ms. Forsberg does reintroduces the concept of a tax equity partnership, but the supplemental direct assumes a production tax credit only without a tax equity partnership. And there are several reasons why that's important, and I'm glad you brought it up because I would like to explain this to you. So, first of all, had staff been aware that the tax equity partnership was on the table, we would have had additional witnesses likely address that concept. And in fact, we sent data requests to Ameren prior to our rebuttal being filed around a myriad of things, but a few of them that are, you know, personal to questions that I asked are for copies of, if not the exact contracts, kind of examples of the contract for differences. And I think Ms. Forsberg's Schedule S1 discusses that at least in some detail. It may be kind of vague, but that there is some reference to that CFD, I think it's called in her.
Excuse me, actually, I think that's in S2.
Okay, yep, that sounds correct. So that being said, we had some other staff witnesses that would have started looking into some of the issues that we may have surrounding the introduction of this tax equity partner. And obviously, they didn't file testimony in rebuttal because that was kind of, I may put this wrong and my counsel may yell at me, but I think it was kind of considered off the table at that point, especially considering that they asked whether or not they could be relieved of actually answering the questions that we had. But we have, and I can speak to just generally some of the concerns that we have with introduction of this tax equity partner. First and foremost, you're introducing yet another.
Your Honor, if I can interject, I don't think his answer's response to your question. And the other thing that I would indicate, it's irrelevant at this point. We swore on testimony yesterday that if we use a tax equity partner, we will come back to the commission for permission related to that, in which case the staff will get a full opportunity to address the issues. I think we're just going into an area that's hypothetical and irrelevant because we may not ever use a tax equity partner.
I see that.
Your Honor, if I may respond, I heard a lot of argument there, but it did not go to the relevance of the question. The only thing that staff did was argue his case and how staff or Ameren was going to avoid the problems that this witness is addressing. That is not our proper objection as to relevance.
My objection was that his answer is non-responsive and that because it is irrelevant, Judge, and I believe that is a valid objection, and I don't think he's not answering your question. He's making a speech about a hypothetical situation where we might or might not ever come back to the commission and ask for tax equity.
I do see your point, Mr. Lowry.
If you'll give me just one moment.
I'm sorry.
I'd like the
Your
judge
Honor,
to rule first before
what was the
you.
ruling? Before you rule on the relevancy objection, I'd like to observe that the subject of this answer and what the witness is discussing is in their work papers, the assumptions that they made. He's addressing the assumptions, and you can't necessarily do that with a yes or no or a 5-word answer. My point is that his testimony is relevant. That's a response to the relevance objection.
His answer is non-responsive to the question you ask, however.
Fair enough. Let me try to rephrase my question. So you would agree, would you not, that what these schedules S1 and S2 present is modeling without a tax equity partner, or am I?
No, the schedules that are in support of Lindsay Forsberg's surrebuttal testimony assume a tax equity partnership in conjunction with investment tax credits, as well as an adder on top of that, which is fundamentally different from the analysis that was provided in support of her supplemental direct.
Okay. All right. Then you've provided me with I think sufficient information. I think previous witnesses have also provided me with sufficient information on that topic. So I don't have any further questions. Is there any recross? Mr. Whips?
Thank you, no.
How about the other parties?
MIEC has a couple of questions.
All right, Ms. Pleshia.
Sure. Mr. Libbert, what do you think the costs are of creating the recs that are part of the RSP?
So can we go in camera really quick for my response?
Yeah, just a second. All right.
Your Honor, just to clear up the record, I don't think his answer was confidential either. He's just talking conceptually about tax equity partners. He didn't talk about facts and figures and terms and so on. So I
Okay.
appreciate
Well,
him
yeah,
being careful, but I think we could just, the whole thing in the transcript could be public.
Okay, yes.
And I move that it be made public.
Okay.
I
If there's
apologize
no-
for the
If there's no
added
objection to
complexity.
that.
Okay.
I'm sorry, I'm sorry, I didn't mean to talk over you, and I didn't mean to talk over you, Ms. Pleshia.
I was talking over
But-
you, I'm sorry.
But, so if there's no objection, then we will, in the transcript, that will not be in an in-camera portion of the transcript. Okay. All right, Ms. Pleshia.
And then my final question is, did you hear Mr. Will's testimony on behalf of Ameren yesterday and stating to the effect that there are no incremental costs associated with the recs under the RSP?
I did hear his testimony yesterday.
Okay. No other questions. Thank you.
All right, Mr. Lowry, do you have recross?
Mr. Lubert, I believe you talked about, in response to some of the questions from the judge, and I don't remember whether you said hundreds or thousands. I think you said thousands or tens of thousands of megawatts of wind and solar in the MISO generation queue is more or less what you said, right?
Correct.
What percentage of projects that apply and get in the queue actually get built? Do you know?
I can't give you an exact percentage, but I will concede that it is a small percentage that kind of to completion, so to speak.
Less than 10%?
I can't give you a percentage, I'm sorry.
But it's way lower than 100%, isn't it?
Oh, absolutely.
So the number of megawatts in the queue at a given time is not a particularly good indicator of what projects are going to get built. Isn't that fair?
It doesn't provide a good indication of which projects would be completed. I'm sorry, I'm not sure if I answered your question.
No, I think you did.
Okay.
I think there were some questions, and I think in your answer you talked about if Ameren let RECs expires, or you made some mention of expired RECs. Do you recall that?
I do.
Ameren Missouri is not proposing as part of the Renewable Solutions Program to allow the RECs to expire, is it?
No.
And I also think you mentioned a case that OPC had brought against Evergy, where OPC, and I'm summarizing the basic point, but I think OPC's point was that Evergy had RECs that it didn't need for res compliance, and it didn't sell them, and that was imprudent. That was the allegation, right?
That was the allegation in that case, I believe.
And the commission disagreed with that and did not sustain OPC's complaint, did it?
That is my understanding of the result of the first time that that was brought to the commission.
I don't think I have anything else, Judge.
All right. Mr. Graham, any redirect?
Yes, thank you, Your Honor. Did Ameren consider selling RECs as part of their modeling presented in Ms. Forsberg's work papers?
No, the analysis in Ms. Forsberg's work papers assumes that I don't believe that they had a value for sold RECs in a scenario where the Renewable Solutions Program was not approved. Obviously, and I think Mr. Lowry alluded to this in the question for me, but in a scenario that the Renewable Solutions Program exists, those RECs aren't for Ameren to do anything with because they're either going to be retired on behalf of the participants or transferred to their name.
You may have touched on this in your response, but my next question is, would a forecast of the REC prices be helpful in showing the viability or prudency of the RSP?
So it would certainly help. I think it would help with the determining whether or not the pricing was appropriate if a forecast existed. I'm not aware of one, but there may be others that are aware of something. But I think Mr. Cunningham mentioned that kind of information is scarce at this point.
If there is a known capacity need in the future, could Ameren advance the construction to meet an energy need?
So I want to restate the question so I'm
going to object to the Senate calls for speculation. There's been no foundation laid that this witness has any idea what Ameren could or could not do. The question's also vague. Advanced construction of what?
Do you mean advanced construction, moving the construction up?
Mr. Graham, how would you reply to that?
Okay. I'm going to withdraw that question.
All right.
Under the proposed tariff, who gets the benefit of the energy produced?
under the Renewable Solutions Program, the participants will receive the benefit of whichever RECs are produced. That being said, the revenues from the asset itself would flow through the FAC just as any other generating resource. Now, I would add that from Ameren's analysis, those revenues aren't going to be enough to offset the costs of the actual asset, and that's very important. But nevertheless, the revenues that are produced will flow back to ratepayers as a whole.
Just answer that next one. You discussed capacity needs and how there is a seasonal aspect to capacity needs. Is there also a seasonal aspect to the purported energy needs?
Yeah, so that's actually a very important point for the commission to consider in this case. So Mr. Michael's testimony provides kind of a glimpse of what the annual energy shortfall might be going out in the future. He gives a few different scenarios, one of which assumes that no additional generation beyond Huck Finn is added. And then another scenario where a potential combined cycle gets added at some point in the future. What an annual energy shortfall doesn't tell you is something that's very important for the economics of the decision of whether or not to move forward or not. And that is that the timing and location of generation and load is extremely important. So a utility might be producing more generation than its load in a given year and lose money on a large portion of that generation, especially if that generation is being bid in at a negative price. So you might be being dispatched and paying $5 per megawatt hour for every megawatt hour you generate. Presumably, for renewables, you might do that because of a tax benefit. But for other assets, you might do that because there's some reliability or maintenance issue that could arise from starting and stopping. And so, especially with kind of large units that aren't flexible in the amount of output, you may operate at a loss for a period of time in order to hopefully in the long run make revenues that would exceed those costs. But looking at an energy shortfall on an annual basis really doesn't tell you much about the economics of whether or not you add a resource. Adding a resource is a locked in win because the timing matters. So kind of contrary to the example that I provided where you might be producing a lot of energy at a loss, there's a chance that you produce a smaller amount of energy than what your load consumes in a year, but the energy that you produced had very high market prices and the revenues were high from that. And so just looking at the total generation compared to the total load in megawatt hours on an annual basis really isn't kind of the best metric, especially given kind of the construct that Ameren is operating in because of MISO. And what I mean by that is that every megawatt hour that Ameren's generating units produce are sold into MISO at a given value in a given time period, and Ameren is going to purchase enough energy to meet its load in every single hour of every single year unless something changes. The fact that you add Boomtown as an asset will not change the amount of market energy purchases to serve Ameren's load.
Can building a facility like this, both for purposes of capacity and for purposes of energy, be redundant?
So that's a great question, and it goes to kind of the economic efficiency that I alluded to earlier. Ameren has a plan to add this combined cycle somewhere around the time that it expects to retire Sioux. And I think what we heard yesterday from their witnesses is that they're going to be replacing the capacity from Sioux with that combined cycle. And largely that capacity need hits a summer need, and this is out in kind of the 2031 timeframe. So if you're building resources now that can only provide, or their best kind of attributes is to provide energy, with the expectation that you're going to build another asset in the future to add capacity that's required to meet MISO needs, the combined cycle is also going to provide the potential to sell energy into the MISO market. And I think looking at Ameren's, at Matt Michael's figures within his testimony, where he discusses no new resources, sorry, the next addition being a combined cycle without the additional renewable resources results in Ameren having a short energy deficit, which I just talked about not being a great metric, but it does have a short duration energy deficit for, let's say, 3 or 4 years. And then you add this combined cycle unit in, and it is back to a surplus of energy on an annual basis. Well, the assets that you're requesting approval for have a 30-year life. And so if you're only getting 3 years of kind of adding to that energy deficit before you have to add another asset, that's not a very efficient way to kind of spend money that ratepayers will end up realizing through their rates.
The word you're looking for, redundancy?
It could be redundant, yes.
I believe that's all the questions staff has.
All right. Thank you, Mr. Lubert, for your testimony. All right, Mr. Graham, are there any further witnesses that you wish to call?
In trouble? Well, no, thank you.
All right. Let's discuss a briefing schedule, if that's all right.
I was going to bring that up myself, Your Honor.
I can tell you this. We have asked for the transcripts to be expedited, and they should be filed in EFIS, and for the sake of the court report, that's EFIS, the Commission's electronic filing information system. They should be in EFIS by February 15th.
Judge, if I could make a suggestion, under the procedural schedule we agreed to in this case, we had agreed that all briefing would be done by March 3rd.
Mm-hmm.
And there's a timeline of the company on notice to proceed in the contract, and that's what's driving that. So my recommendation would be that we have one round of briefs due, unless the commission wants reply briefs, and I may elaborate on that, but one round of briefs due March 3rd. But parties, I guess parties could always file any motion they want, but that the commission at least contemplate that the parties could, say by March 10th, ask for leave to file a reply brief by March 17th if a party believed that it was helpful or necessary to do so, and of course the bench can rule on whether or not we would have reply briefs or not.
Jim, I'd offer something in addition to that, and that would be a request that the commission indicate if it wants reply briefs by March 10th.
Well, I wasn't even saying reply briefs by March 10th, so we would ask for leave to file one.
I understand, but the commission may decide it would desire to have them. And
Well,
if it
that's
hasn't
true.
Spoken earlier that it.
That's true.
The request is that it would do so by
Are you,
March 10th.
Mr. Williams, are you saying at the point that by March 3rd, when the initial briefs come in, if the commission wishes to have reply briefs, that they could make that decision at that time?
Yeah, well, by March 10th, at the same time that parties might ask for an opportunity to provide reply briefs, if the commission's made a decision already that it desires them to do so by that date.
Okay. Let me ask you this, though. Have the parties discussed this timeline?
We haven't discussed this. I think everybody was, I think Mr. Williams would like to have more time, but I don't think he was going to oppose initial briefs being due March 3rd. I don't think we had ever reached any consensus on what to do or not to do about reply briefs. Certainly, the company is willing to have reply briefs in the case and to have them due a month, perhaps a little bit later than that. And obviously, if the commission thinks they'd be useful, we will, of course, abide by whatever the commission asks us to do, but.
And of course, we are completing the hearing half a day ahead of time. How do you feel about briefs initial briefs being due sooner and reply briefs being due by March 3rd?
If we had the transcripts a little sooner, I would feel better about that. What I had originally talked to the parties about was asking that the transcripts be available by this Friday and that we have initial briefs due by the 24th of February. And I know that gave some of the other parties some heartburn. It's a little hard to write the brief without the transcript.
I understand.
I don't want to speak for the court reporter, but 2 days of hearing, 3 days transcript done, I think it can be done. You just have to pay for it.
Your Honor, I know we're never supposed to use the expression press of business, but that starts to create a press of business with respect to the other files that staff has that is burdened with, other rate cases, mock, the water cases and so forth.
Okay, so what
Staff really would be hard pressed to move the deadline for the principal brief up from March 3rd.
Okay.
So if you take that into consideration, so I don't have to mention in a subsequent motion something about press of business.
Hey, I'm not opposed to the term pressing business.
Well, I don't like to file it on top of a deadline. I like to bring it up before the deadline is set.
Fair enough. So I'm perfectly fine with one round of briefs due March 3rd, and we will leave it open to motions for reply briefs.
And then I guess it could be leave open in terms of the date those would be due, depending on what the motion is and considerations are.
Right.
That seems fair, Judge. Thank you.
Okay. All right. Then if there's nothing further, I'll adjourn the hearing. We'll go off the record. Going off the record.